It's your girl Mickey Truth, aka the Queen of Paperwork, baby. And I am here, and I am early. But y'all know how I go. I'm early, but I'm late. But I'm early to my lateness. And I just decided to go ahead and get this live started because, hey, we have a recap to do, okay? I hope today has been great for everybody. Everybody enjoyed their holiday for those who was able to use today as a holiday. But for those who did not, I hope you went and got them coins, okay? Now, before we get into everything else, let's just go ahead and start this thing off right. And y'all already know what we're going to take it to. Yo, Hookah, what it do?
Hey, what's up, y'all? It's Hookah Anonymous, and you are now rocking with Mickey Truth. She live up to her name, not the fame. So make sure y'all subscribe to her channel and stay updated on what's real. Bye.
Coming from where I come from, they doubted me, but I came up. I made it through the storm, trying to conquer the world. I made it through the storm, trying to conquer the world. Coming from where I come from, they doubted me, but I came up. I made it through the storm, trying to conquer the world. I made it through the storm, trying to conquer the world.
Good reporting ass Mickey.
We love you, Mickey.
We love you, Mickey. I love that part. Shout out to my daughter who says that part on the audio. Yo, y'all let me know if my audio is good. I got some headphones on right now. What it do, GTA? What it do, Trigger? Yo, like, comment, share, tell a friend to pull up. And we is live. Y'all already know what we doing today. We are recapping all of last week, man. We gonna make sure we understand to the best of our ability here over here on the Truth Team channel, you know, so that tomorrow we kind of know what we're looking at, okay? Because I ain't gonna tell y'all no lie. I was kind of like, what does this mean, right? We're waiting to hear, will it be a mistrial announced tomorrow? Will that be a good thing for Melly? Or could that pose a problem? I don't know. We're going to try to see if we can figure out tonight, you know, so that tomorrow, for those who don't know, I am going to stream live beginning at 9 a.m. Eastern time, okay? Going to stream live to the inner court. Whew, yes, I don't know how long that's going to go, but we're going to be there until from start to finish. So make sure you pull up on your girl. Yeah. A couple things came out. I think I wasn't going to really talk about it, but I think, you know, might as well, right? So if y'all are not aware, interrogation video was dropped. And it's supposed to be Melly, to be honest. I'm not sure if y'all know, you know, that Melly, when he was about 16 years old, was charged for shooting on school property. I'm actually going to use a video, but first I want to get into the news clip because he was 16, meaning he was a juvenile. I'm kind of confused to why or how his name got released because he wasn't charged as an adult. But nevertheless, we got the news clip. I'm about to pull it up right now. Trigger said the feds on the way. You think the feds gonna step in on this one, Trigger? Why you think that? Let's see here. So this is the only news clipping that I can find from it. And it's from TC Palms. And it says teen charged with firing gun at group near Vero Beach High School. And this was published October 20th, 2015. It says Vero Beach, a 16-year-old boy was charged Monday with firing a gun at a group of people near Vero Beach High School, police say. The shot was fired about 2:26 p.m. Monday in the 1400 block of 16th Street, east of the high school. 3 people told police that the teen Jamal Demons, I'm not sure if it's Jamal Demons, had fired the gun towards them, but no one was struck, police said. Demons, a student at the Freshman Learning Center, was charged with 3 counts of aggravated assault with a deadly weapon and 1 count of discharging a firearm in public. Police said they recovered a semi-automatic weapon Monday evening after Demons told officers where it could be found. Demons was being held at Juvenile Justice Center in Fort Pierce. Police said a 911 call was made when the group was gathering outside a restaurant in the block. Shortly after the call, gunfire erupted, said Vero Beach police spokeswoman officer Anna Cardin. The three people who demons was aiming at are students at Vero Beach High School between the ages of 17 and 20. Cardin said, there's no indication the dispute between the students started on campus, though police would not comment what led to the shooting. The shooting, which was not on school property, came about a month after two students from the Freshman Learning Center was charged with carrying guns on campus. The students told authorities and their attorney they were carrying the guns for self-defense. Treasure Coast newspapers customarily does not name juveniles accused of crime, but does name some juveniles depending on the seriousness of their crime, their age, aggravating circumstances, and other factors. Okay? So, hey, I guess that answered the question of why they are posting his name. I mean, he was 16. Now, let me see. Trigger says, family matters and they pushing for justice. Now, let me ask y'all this. Do you feel like that would be the sole reason why the feds will step in, though? Because to be honest, there's a lot of families that push for justice, but that doesn't necessarily mean the feds will come in. But I think that is the angle we can look at. Will this be a case as to federal, authorities will step in to pick it up if he's outed, if he's found not guilty? Well, not guilty. Mistrial. Let's not do not guilty. The mistrial, right? I do know, I'm not sure exactly the timing, think it's a time level. So I wonder when that timer starts. Because at a certain point, they can't even pick up the charges even on the federal level. Not sure what that time frame is. We'll see if we can find it. But yeah, so we're going to definitely just dig into everything across the board. Exactly what would happen. Now, personally though, when maybe I might change my mind once we dig a little bit, but just off the top of my head, I personally don't think the feds will pick it up because I felt like if it was enough for the federal government to take charges on them, they would have did it instead of the state. For example, if we think of FBG Duck, his murder never was picked up by the state. The local police definitely was investigated from the start. However, charges was not filed until the feds did it because they was going to take them down on a bigger organization. Now, is there potential that it could have been a feds case? Personally, in my opinion, yeah. But now that the state done touched it, I don't know. I don't know about that one, especially with a murder. I'm not sure. And then let's just see. We're gonna think about it, and then we're gonna see what's up. Let me see. What it do, Lamar? Lamar said feds not picking Melly case up for real. The feds don't even be caring about bodies unless it's a RICO indictment. Now, I will agree with that. And see, that's what I was going with as far as with the whole FBG Duck. See, his murder got picked up with the whole situation because of the bigger conspiracy or racketeering. But I don't know. I personally just don't see the feds doing it. Possibly, this is my thing. Like I told y'all, right? I think the state of Florida messed up for pushing. They spent so many years to make sure it was a death penalty case for one, but they didn't really filter out their evidence, in my opinion, right? I feel like if they would have tried the co-defendant first, then Melly, maybe it would be different. I personally just don't see how all the evidence screamed death penalty for Melly when the only evidence we're seeing is like, as far as to be like, boom, red-handed is Bortland. Everything else is circumstantial. Like I said, I am interested in finding out, if we get to that point, if a mistrial is not done, where did Melly go? Like, why is Melly not in the car no more, right? Like, things like that. But as far as the only gunshot residue you got is on the co-defendant, right? The only person you actually see with the bodies is the co-defendant. The only statement out of the defendants that you have is the co-defendant. You know what I'm saying? It's like everything points the other direction, which is crazy. Now, what we are going to do today, we're going to get more into the Arthur hearing for Bortman, okay? If y'all recall on I think that was day 2, I got into the transcripts just a little bit. But today we're going to get into them. We're going to see what they say. And the reason why I feel like going through that would kind of help us, because my whole question has been since the time I touched this case to now was, why didn't Bortman get the death penalty added to? Or why is Bortman being like, why is he out on bond? Like, you know what I'm saying? I always wonder that, like, why? So let's see if the Arthur hearing will, give us some insight to that. Let me see what it do, KG. Lamar said the DA on Melly case definitely seems like they tried Melly case because he was a popular rapper, which is cool, but that might be the nail in the coffin too, because at this point, and we're going to revisit what has been thrown out, what is still there. We're going to revisit that because some of their biggest pieces of evidence are gone. Now, I was going to play the interrogation, and then I wasn't. I kind of just feel like at this point, it really doesn't matter to me, right? Because at the end of the day, I know on this case, so far, nothing has ever been released that he has said anything as far as Melly on this case. And I just think it's like, that's really not my cup of tea as far as really caring about if he actually told, especially on the old case, because it doesn't have any bearing on this case. I'm going to leave it alone. However, 1090J did go ahead and do a video in regards to it. Definitely check that video out. He tells you the info from the beginning to the actual interrogation. And I think Chirac Rares is the one that actually dropped the video. Look, shout out to them. Mickey just gonna stay over here in my lane and get to the paperwork. Because like I said, juvenile case, can't get paperwork, isn't intriguing to me. Just thought I'd mention it since it is, trending right now. So let me pull up Broward County real quick. So while I'm doing that, y'all let me know, do y'all think at this point we're going to get a mistrial tomorrow? And I said weird because, we over here, we play jury on this case, okay? We don't have nothing to do with nothing, but just for our conversation purposes, what y'all think? Oh, and I do want to get into some of the social media of like YNW Melly's mom, because she posted something the other day. And I don't know if it'll still be up, but I'm going to see if it's still up. That was interesting. And I honestly, I was like, wow, I kind of definitely had some empathy in regards to it. Now, does it take away the fact that I still am kind of confused why she got immunity? Yeah, I'm still confused on that. But nevertheless, this is a son on trial for death penalty, okay? All right, let me see. Lamar said, how was they able to release the video being that it was a juvenile case? That's a good question. KG said everything didn't get thrown out, so do you really want that? As far as the mistrial, I don't know. I'm going to break it down and see what I can find, because to be honest, I don't really understand what's really the pros and cons of it, because I do know even if a mistrial is granted, they can still retry, and I don't see the state spending so many years on a case just to not retry it. So I'm definitely gonna try to see what I can find. So I don't know, but I will say I don't know if I did say everything. My bad on the wording, but what I meant to say was some of the biggest pieces, okay? Because For those who have not followed the case from the beginning, that 2018 statement by Felicia Holmes was a big blow. Real big blow, okay? Because that statement, 2018 statement, had a lot of stuff in it, okay? And the judge, and I'm going to replay it back, but the judge threw it out and said it only can be referenced to the deposition. So, what dad, KG? The dad that we listened to the other night? Now, I told y'all when we listened to that first clip of, I think it was YNW Juvie dad talking, I told y'all I ain't know how I really felt about it as far as the information about the case he was giving, because it seems like he wasn't in the know, right? It seems like he's probably outside at this point looking in, personally, just in my opinion, based off the wording he chose to use. So if he did say it's a lot more, then maybe it is, but I'm just not convinced just based off his statement that he actually knows what they have. Now, but what we can do is look at what they put in their own words as to what they have. So what I want to do is take it back a couple years, right, to 2020 to be exact. When I found this article, I was kind of like, really? And once I read it and show y'all, y'all will understand why I'm like, really? But before we get into that, make sure you already know all information contained in this video is for entertainment and educational purposes only. All information used in this video is per the Fair Use Act. And more importantly than anything, any conclusion that you draw is on you, not me. Okay? All right. So let's turn here. All right. So this is, now again, this is just an article. This has nothing to do with the official Broward County, but look at the wording of it, right? Just look at it, right? So for one, it says, audio surfaced of YNW Melly allegedly confessing to past murders, okay? Then, let's just read. Let me see what y'all writing. If I'm Melly or his defense team, I wouldn't want the judge to rule a mistrial because all of the state going to do is retry it. I would just go with a acquittal. Okay. All right, so the article, and we're going to get into the meaning of those too in a minute so that we can all be on the same page, because some of us may not know exactly what that means, acquittal, and what exactly a mistrial is. So once we finish this document, we'll get into that so that everybody can have an understanding on what it means as we go through the information. Excuse me, y'all. All right. So it says, now this was posted November 7th, 2020. What it do, Dom? YNW Melly's alleged double homicide case may come to a close as an audio recording of the rapper has surfaced, in which he confesses to the double homicide charges he received in 2018 for the murders of YNW Stat Chaser and YNW Juvie. In early 2019, Jamel Maurice Demons, otherwise known by his stage name YNW Melly, turned himself in at the double murders of two other rappers in a YNW collective. October 26, 2018, Christopher Thomas Jr. and Anthony Williams arrived at Memorial Hospital, Memron, due to, and I know I said that wrong, multiple gunshot wounds sustained by both men. The men did not survive and declared dead at 4:35 a.m. upon arrival. Then it says, okay, the names, we already know that part. Now, let me just go down some more, because we're kind of going down. Now, this is the thing that I'm like, misinformation is crazy. All right. Now, I don't know. I wasn't watching this case in 2020. If y'all were and y'all remember this, y'all let me know if this was true. But here it is. It says, the main piece of evidence towards the case consists of a 40 caliber handgun found in the car, proving that Demons had been in the car the same night of the shooting. This matched the casings found at the crime scene. Other evidence that incriminated the Florida rapper included cell phone records and surveillance video. Did y'all ever hear of that? I never heard of it. And I for sure ain't hear it when they started talking to the ballistics expert. Did y'all ever hear that they found the gun in the car? Cause that was one that stood. I said, really? Y'all let me know if y'all ever heard that. Because that was interesting to know that was a big piece of evidence at one point, according to this documentation, right? All right, let's get to it. Let me pull up the other case here. All right, so Broward County online, we got Cortland Henry, aka YNW Portland. This is where we're going to be looking at the documentation today. And for this reason is because a lot of the information that may answer our question in regards to why Portland, for one, wasn't tried first, for two, why so much evidence is against him in our eyes, but again, he's out on bond. He's not even facing the death penalty. So let's see if we can find out why that is. And hopefully, you know, that can help us in regards to finding out exactly what the future of this case would mean. So they have the final DNA lab submissions and reports, which is 8 pages. Okay. And what I'm doing, for those who are wondering, I'm just hitting on all their discoveries that was recently submitted. Because one thing I noticed, some of the information is different on what's available on Portland's information and what's available on Melly's information. All right, let me see what they got. Digital evidence, aerial photos and videos, the police report in a new format. Okay. All right, so this, what is this? All right, what's this? Second GSR report from RJ Lee Group dated March 29, 2023, 3 pages. All right. Well, we already know the GSR they presented in court, I think on day, was it day 4? They talked about it and they said they only found residue on Henry. And for those who don't know, possibly maybe the reason why that's the only person was because they didn't get in contact with Melly until months later when he was arrested, when he turned himself in after the warrant was issued. All right. Going on down. All right. We don't even look at that. Let's do this one first. All right. Oh, this is the one we already looked at. Hold on. Pause for the cause. I forgot. That's the one we looked at already with the addresses on it. Not that one. I don't feel like having to edit that out. Let's see here. File affidavit. All right. Let's see, what does this one say? All right, so this one is the same one that we already had. And I believe we went over this, if I'm not mistaken. Let me see. Y'all refresh my memory. I think we went over the search, right? Of 100K Didn't we do that already? I'm trying to remember. I know I did it in February, but did we do it last week? Y'all let me know in the chat. I don't remember if we did it. I think we did do this. I'm scanning through. Yeah, I think we went through this. All right, so we can go further up. All right, let's get into the motion to set bond. Let's start there. Let's see why from the beginning, why he was able to get bond and not Melly. So let's see. All right, so y'all remember I told y'all the Arthur hearing that we're going to get into the transcripts of the Arthur hearing. This is important, and I want y'all to understand, because some people got it confused with Arthur hearing and Arthur plea, and I want to make sure that we know the difference. All right, so what is an Arthur hearing? For many crimes, a defendant may have the ability to pay money for bail. In fact, in the state of Florida, most everyone is legally granted the right to bail. However, for certain capital offenses, including murder, for example, murder, there is typically no option for bail. When this happens, the defendant may be able to ask for an Arthur hearing. Unlike most court trials, the outcome will be determined by a single judge and not a jury. Other than that, Arthur hearings often resembles a small expedient trial. So it gives you an example of the crimes that you can request if you get this armed robbery, kidnapping, murder, sexual battery, lewd conduct towards a child, armed burglary. Then it even goes on to explain how is bond granted through an Arthur hearing. So it says here, in Florida, an Arthur hearing may be held to see if the defendant should be granted a discretionary bond. An Arthur hearing consists of two parts, phase 1 and phase 2. In phase 1 of the hearing, the judge considers testimony in a mini trial. The burden of proof is on the prosecution, and she must establish that a crime was committed by showing proof evident, presumption great. This means that the prosecutor must show that there is no question of the defendant's guilt. It is very high burden. Next, in the phase 2 of the hearing, the court considers whether a discretionary bond is appropriate. The court will consider certain factors, such as the seriousness of the crime, the defendant's prior record, and whether or not the defendant poses a flight risk or a danger to the community. If a bond awarded through Arthur hearing and you believe it to be exorbitant, you may have the option to reduce. Okay, we don't need that part. All right, so y'all get what it is, right? Arthur hearing is where you request in a so-called quote-unquote mini trial. The prosecutor is going to present evidence that they have at the time. The judge, not a jury, the judge is going to say, you know what, that's not enough to hold you without bond. So we're going to grant, or I'm going to grant you bond until you actually have a trial. So just based off knowing that YNW Bortman is out, his Arthur hearing must have went pretty well. So that's why I wanted to get into the actual transcripts of the Arthur hearing, so that we can see exactly, what was said. All right, let's start here. Now, this is motion to set bond with memorandum. All right, so they break down basically, I'm not going to read it in verbatim, but y'all can see it on the screen here. Let me see here. What's up, Prince? Prince says plus he was on house arrest and that matches if he couldn't pay his bond. Gotcha. All right, so it breaks down this. Let me see. All right, so if you look here, now this is his motion to the court, okay? It says here, let's start with the count. I want to make sure we get it. It says defendant Cortland Malik Henry and another are charged with the offense of first-degree murder, and Mr. Henry as well is charged with lesser offenses of accessory after the fact in an indictment that recites. Okay, it goes into detail. If you look on the count one, they are already saying, if you look, that Jamal Demons did actually possess and discharge a firearm. As a result, death was afflicted. Okay, inflicted. And then it says the same thing for count two. So basically they're saying in the indictment itself that Bortland was not the shooter. Melly was, okay? So that's one thing. Now the other two charges here, it says here that, let me see what his name is. So now it's saying that Bortland Bortland planned or purpose, maintained, assisted, or aided or attempted to aid Jamal Demons. So that there is the other two charges. So each of the four counts, they're saying Bortland was basically the sidekick to Melly. Okay, they have Melly first and foremost as being the center point of each charge, even accessory after the fact. Now, it says here that the decision was made April 25th, 2019, that Bortland would not be receiving the death penalty, okay? And said the state of Florida made that decision. Y'all see it at number 2. Now, number 3, it says, as shall become, I hate all these wordings in these documents. That's why I'll never read them verbatim. So I'm going to summarize them, okay? It says here that the defendant would argue there is no evidence or proof that the defendant was involved in, yet alone committed first-degree murder to the extent necessary to deny bonds for Mr. Henry. Okay, so to summarize that in more layman's term, basically I ain't got shit on me, so I shouldn't be held with no bond. Basically, that's what it said. Says no evidence or proof that he did anything, including the indictment that says it wasn't even him that did it. It was the co-defendant. Now, next, which is number 4. All right, so now they're saying that the evidence that they do have basically go more towards the accessory after the fact. Yes, Lamar, Bortland is facing accessory after the fact twice. And basically what his team is saying that the evidence that they do have is greater for Bortland in that role, not in the murder roles. Now, let's see here, number 5, and I'm skimming through. All right, so basically they said the state in this matter must establish that the proof of guilt is evident. So like without reasonable doubt. You see how that's important? Without reasonable doubt, basically, they must show like, yo, the evidence does not go towards them. No, he does have murder case, Lamar. He has 2 murder cases. Charges. Let me not say cases. 2 murder charges, 2 accessory after the fact charge. However, in the murder charges, even in the indictment, it says basically that Jamal Demons is the shooter, not him. All right. Now, let's look at the facts, okay? And this is the facts per this document. It says the affidavit for arrest for Bortland, right? Dang, all these doggone things here. Hold on, let me just read it and then summarize it, because All right, so they basically saying that in the affidavit, and y'all can see it on the screen if y'all want to read it verbatim, but the affidavit is basically stating that it's nothing in evidence that shows that Borland even committed a crime, right? That basically they have nothing to go against him to say that he should be held without bail. Now, it goes into community ties and prior record, and it basically states here that he was a lifelong resident of South Florida. He's going to reside with a close friend if he is able to get out. He's a recording artist, a clothing designer, and basically he'll have a job. Said he has no passport, would never leave the country. Has prior arrests but no adult convictions. And if y'all remember, when I ran the story the first time, I talked about the case that him, Melly, Melly's girlfriend, and a couple other people, and I think it was Sat Chaser that caught that case with them too. Like maybe a year, was it a year before the murders, or maybe the same year as the murders, they had a case all together. I don't know. Let me see what Lamar's saying. Hold up, Mickey. Didn't Portland get locked up for violence? We got to get there. Lamar, like, let's jump to it. But yes, what it do, New Age? Yeah, we got to get there. So right now, we're at the point that he's in jail, has not got granted bond yet. So, but we're going to get there. But yeah, you are correct. That did happen. All right. So this document here was filed before he even got out at all, because under their statute in Florida, when you're charged with that type of crime, is automatically no bail. The only way you can get a bail is if you get an Arthur hearing and you're able to provide the information needed. All right, let's see here. And it even breaks down right here why, right, they're needing to do a memorandum and support a motion for bond. And it says here that it's a non-bondable offense. All right. Let me see what else. I'm skimming through, y'all. Skimming through. So basically here, they're saying that they got some evidence, meaning the state of Florida, but not that strong of an evidence to say, like, yo, he shouldn't get bond. That's basically what that summarized to be. They put some, some legal jargon in there. Oh, we can skip that. More legal jargon. All right, so basically that's that. All right, now let's get into the Arthur hearing itself. So, according to, hold on, before I get there, let me show y'all. All right, so according to this document, right, that was filed on July 15, 2019, the Arthur hearing was scheduled for August 23rd, 2019 at 1:30, and y'all see it right there. All right, so if I come here, y'all see it, transcript, Arthur hearing, Henry, what the hell? Make sure y'all like, comment, share, subscribe, tell a friend, pull up. I'm gonna get my words together at some point today, okay? I haven't even been talking a lot today. I don't know why I'm getting all twisted. But anyway, y'all already know. Some words may come out good, some may not, but we're going to still talk about it. So let's click on this and get to the business. All right. Now, I think that's big as I can get, okay? What you said, KG? KG be on one. He said, I'm about to tell Henry to pull up. Don't tell Henry to pull up over here. Not today. Another day. Look, they be like, we was watching a YouTube live, and Henry said this over there on Mickey Truth channel. Tell him wait. Don't come today. Come another day. KG trying to set me up. All right. Let's see here. And as y'all see, I'm gonna say soon as it does it. All right, so in this transcript, it's not gonna have no state witnesses. The only witnesses that is shown is Courtney Henry. I mean, case in point, this is his hearing, so he should be there. No exhibits for evidence are going to be called for the state or the defense. And again, this happened August 23rd, 2019, about 2:45 p.m. Hold on one second, y'all. All right, I'm back. So I'm going to skip through a little bit. I'm just going to skim through. So it just says the defendant, Mr. Henry, is there. Y'all know that name. Kay Bradley is the prosecutor on the case. So the same prosecutor that we see in the courtroom for Melly is the same prosecutor that's at this hearing. Okay. All right. Now it says here, this is the judge. Anytime you see the court, that means the judge is talking, right? And it says, all right, so what I have right now is I have Mr. Henry motion to set bond for the Arthur hearing, which we're here for today. I have a packet of information that's being presented to me in a bonder that has been provided by the state and the affidavit supporting the information. Okay. Then someone by the name of Mr. F. Haddad said, and I'm provided a couple affidavits in my motion. So Mr. Haddad, and I don't know if that's how you say it, is the lawyer for Mr. Henry. And if, let me go back before I say this. I think he is a lawyer. Yeah, Mr. Haddad. So I don't want y'all to be like, that's not right. So on behalf of the defendant, so Mr. Haddad is a lawyer for him. Okay. All right. So the prosecutor, right, is stating here, at this point, the state is going to put on a little bit more of a cohesive theory as to how all the different items that you have are involved. Well, hold on, because I don't know about y'all. I need to know what that means, for one, before we continue. If y'all know what it means, feel free to put in the chat. But I ain't gonna hold y'all. I don't know what cohesive in this context mean. Are you serious? Like, that's a BS definition. Have you ever seen a word with the word in it? To like, that's crazy. Okay, Lincoln. Okay. Thank you, Prince. Put it together. All the, I can't see it on that. Put it together, all the police statements. Okay, yeah. So that's what I saw on Google too, was Lincoln. So okay, gotcha. All right. So they're basically about to put it together, okay, in theory. And we all know what theory means. Theory doesn't mean the shit show, but theory means theory. Like, this is what we think. This is our guess, okay? All right. So the prosecutor starts talking about the whole background to the shooting. I'm not going to get too much into that because we kind of know that by now. Yeah. All right. All right. This is where I'm going to start at. So we look down at line 23, right? It says, so There is no dispute as to when they left. If it's all caught on video and also captured with regards to the cell phone evidence. So the cell phone evidence is probably the biggest part of this case. And it is some of the most difficult to understand just looking at a bunch of X and Y, GPS, latitude, and longitude. That's why I also provided to the court the cell phone videos. Okay. So let's just jot down some notes, truth team. Y'all know we got to get in our truth team jury mode. Just so later on we can understand it, right? Y'all know me, I got my papers. Because I'll be the same. I'll be asking Prince all night. Now, Prince, what was saying on page 5? All right. So they're saying cell phone evidence. None of my pens never work. Hold up. All right. Cell phone evidence is the biggest part of the case. So that's big. Right? Then it says that basically they have a whole bunch of the GPS of the cell phone. And also the videos on said cell phones. Okay. Y'all with me so far? All right. All right, let's keep going. All right. We got that. Now, at line 13, they do specify that we already saw in court that Bortland was the one that came to the hospital with the deceased victims. All right. Mm-hmm. They describe the clothing that Henry is wearing. Mm-hmm. They describe the clothing that Sack Chaser is wearing. All right, now they're stating where everybody is sitting at. Now, I want y'all to pay attention to this part here. Starting at line 19, those are the occupants of the red Mitsubishis, right? Trayvon Glass, Dontavius Withers, Jacoby Mills, Adrian Davis. Okay, now, Dontavius Withers, which we heard, well, not heard, let me take it back, which we saw in the original arrest warrants, stating that he told a lie. Originally, he said that Melly was in the car with him. Then he said that Melly hit him up on Snapchat to pull over. You know what I'm saying? We saw all that in the original arrest warrant. Then we also saw Jacoby Mills in the original arrest warrant is allegedly the one who stated he saw the gun, right, in the woods, and that he was there when 100K Track took the gun and got rid of the gun. Okay. Now, Adrian Davis is a person listed in the discovery. Now, I saw on another YouTube video that he has the actual transcript where he provided a deposition. That deposition is not provided online. I have requested that transcript. However, one thing about it, down in Broward County, if you can't get it online and you have to request it, you have to do everything by mail. Like you have to submit payment by mail and everything. So I am waiting and have not gotten it. So I'm not really sure exactly if he is a threat to the case towards either one of the defendants right now. So I don't know what exactly did he say. So we're going to put a pin in that one because I don't know what he provided. Trayvon Glass is another person listed that they requested a deposition from. At this point, and we're going to verify as we go through all the information, I cannot tell you if he provided a deposition or not. I do know he is listed to give a deposition. The defense even requested, as far as on Melly's side, for an address for this person because they wanted to get a deposition. But from my understanding, the last time I checked, he didn't provide one. But again, don't know if he's an asset or a liability as far as either defendant at this point. So the only two names that we know that provided the statements in 2018 is the Dontarius Withers and Jacoby Mills. But again, these statements were to police, not to officers, not in a deposition, which we learned in court last week is a difference, okay? And we'll visit that again because we learned that with the Felicia Holmes statement. All right, let's see here. And it even says here at number 22nd, then you have sworn statement from some of those for your honor to review. So there you have it. All right. Now, it then goes to say, one of the other very important things in the cell phone records that the state provided as State's Exhibit number 21 is the records of both Mr. Demons and Mr. Williams. So that right there is stating that's a very big piece of their case is the records for Melly and Sat Chaser. I'm writing that down. All right. And then it says it's important to know that they both have the exact same type of cell phone because Mr. Demons had brought those the cell phones per the statements and per the records recovered from AT&T and T-Mobile, Sprint, and all the cell phone companies are in here. These particular cell phones, which are both iPhone 10s, were on the T-Mobile network. And so T-Mobile has a very interesting feature where it will tell you the environment the cell phone is in. Then it says, from these cell phone records, I can tell you the exact moment Jamel Demons got out of the car at the staged drive-by shooting location because his phone goes from mobile, which had been from the entire time that he left the recording studio without stopping, and it never gets out of stationary until they get to the scene of the shooting where it occurred. So right now they have the phone evidence per the telephone company, which is in Melly's name, which that's how they're confirming is his phone. Y'all get that part? That's what's going on right now. That the reason why they're saying it is in their belief that that phone belongs to YNW Melly is because it's in his name and they have him in that car. So, like, hey, this phone bill says your name. We have you in the car, so that got to be you moving around with that phone. All right. So they do say they staged the drive-by shooting at this hearing also. And they do also say that Anthony Williams, aka Sat Chaser, who was already deceased by the time this staged drive-by occurs, his phone says mobile the entire time. What it do, mogul? All right. So one of the things I think was floating around was if Sat Chaser. Now they don't mention Juvie at this point, but it does say that Sat Chaser was already deceased before they staged the drive-by, allegedly, right? So we can say that they do say that in the documents, Now, all right. Now, they say at the time of the bodies being taken out of the Jeep at the hospital that Melly, right, is mobile. And again, they say this is Melly because it's his phone and his name, and they saw him leave the studio in the car. Now, they also say phone calls are starting to be made, including to his girlfriend, who then testifies and says he called me. Now, I don't know when this testimony took place. But that's what this document says, that she testified and says he called me. He was outside on the side of the road and asked to be picked up, right? Then it also say that Melly's cell phone records, he sends another drop ping to another individual asking him to come and pick him up, okay? Now, for those who don't know, this particular part is for referring to Fredo Bang. And I don't know if this is a document that's going to say it, but if it doesn't say it, that's who they're referring to. It was in opening statements on day 1. Now, next here, right? And I just want to point out something. Have y'all noticed in this hearing how Melly's name is said so many times? Don't that remind you of the trial where we're hearing so much about Portland but not Melly? Isn't that crazy? She means testify like speak the truth, not testify as and have a statement. Okay. Well, I do know in 2018, and this is only per the paperwork, is that she did speak to police. And matter of fact, they said it in trial. They asked her mom about that meeting. So she does provide a statement at some point. So I guess that makes sense about using the word testify. All right, let's see here. Now, they do go into detail about Mr. Henry, aka Bortland, about his phone. It said the phone was broken and said they were able to back that up between messages between Bortland and Melly in the days leading up to the event. Now, what's weird to me, and y'all can tell me if it's not weird to you, maybe I'm just overthinking it. How can a broken phone to the point that he would not have it on him be verified by messages? I would think you can't use the phone, right? If it's broken, like how did you see messages? But nevertheless, that's what they say. All right. So it says here, Melly phone is in the purple. Fat Chaser has a lighter blue phone. Oh, hold on. Yeah, Melly's phone. So I guess they're referring to maybe the actual like breakdown on the phone records. I don't think they're talking about the actual phone. So Melly's purple, Sat Chaser is blue, and there's a yellow is 100K track. And it says 100K, and I'm just using the nickname, is a manager for musical talent, Melly. So we have in green is Juvie, and at the top is Withers with yellow. All right, so they do break down the path that they took based off the phone. So how they see, they can tell that Melly and Withers are in 2 separate cars. So that's basically what they're explaining now. Let me see what Prince says. Prince says, when did Cortland even get a phone? I don't think they ever say, to be honest. I'm not 100% sure about that. All right, let me see what's next. All right, so they're still talking about that cell phone. So right now, they're again, the reason why they're pinning that phone to Melly is because it's in his name. They saw him get into the vehicle. They then are able to piece together that that phone that they're believing to be Melly is not at the hospital. It's still in the same area of the shooting. And again, like I told y'all, a big piece is where's Melly, right? If Melly got in the car at the beginning stop, but not in the car at the end stop, it's definitely some shaking, like scratching your head, like where he at then? Okay, my bad. Shoot, I stretch and end up yarning. All right, let's keep going. All right, so here we go. It says This is the point at which he is assisting and aiding and abetting Jamal Demons committing the homicide of the other two individuals. So at this point, they're saying they can tell by phone records that the two cars, the red Mitsubishis and the Jeep, which had Bortland driving, are now going in separate directions. They say at that point is when the accessory after the fact or the aiding and abetting begins with Bortland. They said also they have cell phone records. They for all but the other three in the red Mitsubishi. Well, if they do have cell phone records for everybody else, they haven't said it yet. So far, the names that I just said was the ones that they got in here. So not sure, but it may be on Discovery because it's like 100 pages of Discovery throughout all the documents. All right, and it says he is not going to the secluded location where there's nobody else around. You can also say there were no other people there based on the warrants that were done in this case. All right. All right, we already talked about that. Okay, so here goes something, right? So it says that Melly, his phone, along with Set Chaser, travel out to Pembroke Road in 27, and then at which point they take a non-direct path to the hospital. Okay. They stop at a location where the firearms were disposed of, and then the firearms are then picked up later that morning by Henry with Melly 100K track after Henry is discharged from the hospital. And that's what it says right there. Hold on. What it do, Bo? So, based off what they're saying in these transcripts, at this point in this Arthur hearing, which is the hearing that Bortland's lawyers asked for to get him bond, they are saying the following. They are saying the biggest part of their case is cell phone records, GPS, and cell phone videos. They are pointing at that Jamal Demons, aka Melly, is the murderer, right? And that Bortland was just the aiding and abetting, basically the accessory before and after the fact, right? They also say that the phone records that they're tracking for Melly and Sat Chaser is in Melly's name because he purchased them, right? And that because they saw him get in the car at the studio with a phone that's in his name, right? And then once Bortland and the two bodies got to the hospital, that phone stays around the shooting location. And also, guess what? Where's Melly? Not in the car at the hospital. So they're assuming in theory that that phone is still with the person missing out of the car, which is Melly. Now, let me see what else I got here. That's where I got it so far. But now it is confirming at this hearing. Now, again, like we read for the definition, the Arthur hearing is a mini trial to provide evidence to the judge who makes a decision whether or not the non-bondable charge should be lifted so that the defendant can get bond. Okay. Now, it says here that, right, the location of the firearms is being said in here and said that 100K track was indeed with Melly and Bortland after he was discharged from the hospital to get the firearms. Okay. Then it says that Melly leaves to go to the video shoot. Yo, you know what I just thought about? Does Melly still have this phone at this point, right? So I can't believe I haven't thought about that before now. So the phone that they're tracking the night of the murder, right? Is Melly still using that phone at this point? Because it says that Melly goes to do a video shoot. So does he still have this same phone, right? Or, you know what I'm saying? Like, are they still tracking him that whole day with that phone. So that would be very, very important and harder to disprove that you didn't have the phone because, I mean, although they may not have the video, whatever to say, without a doubt, it is suspicious though if this phone that was tracked around this murder is now tracking wherever you are shooting this music video, and a common denominator is you. I don't know. All right. Hold on, y'all. These messages coming up slow. I see Prince wrote something. So I said, yes, that is why the manager giving it up is senseless. That's crazy. Okay, so here we go. Then it says, this shows Demon's phone and Wither's phone together. This is important because you can see where they diverge. And that's the time frame in which the state is relying to show that Cortland Henry knew what Jamal Demons was going to do and help him make it easier to commit by taking him to the site of the Everglades. So I take that as being that Portland is in the driver's seat is the reason why they're saying, yo, without a doubt, it's not. Now, think about this, y'all. Just think about it. As a jury, right? They're presenting this evidence to us, right? They tell us, they show us the video of the studio, everybody getting in their prospective seats, right? They show us the video of everybody at the hospital except Melly, or except the left rear passenger that we saw. But we now see, right, that the driver tests positive for gunshot residue. But we don't have a positive test for the rear passenger. So the same way we don't know when Melly, right, got out the car, or if Melly was in the car the whole time, how do we know Portland was driving the car the whole time? You get what I'm saying? Like, that would be tricky to me, because the same way we can say or cause doubt that Melly was in the car the whole time, wouldn't the same reasons apply to if Portland was driving the car the whole time? So, I mean, I'm just thinking realistically, like, it have been plenty of times I've swapped seats and may end up back in the same seat I started at. For example, me and my husband, I don't like to drive. It have been times he done started driving. I may have left driving. And maybe when we went somewhere and got out, he drove, we went somewhere else, and then I got back in the front seat and come back. Now, when I come back, you may be like, oh, you drove the whole time, but the whole time I didn't drive the whole time. So, that's something. Let's see. Did you talk about the mistrial request yet? You think the judge gonna grant it? He looked like not at the time. No, we haven't got there yet. We're starting with why Portland got bail and Melly did not get bail originally. And then we're gonna work our way up there. All right, let's see. Yeah, my bad. My comments are coming slow because I see it on one screen and then I gotta wait for the other one. You look like a scarehead driver. I would probably want to drive to. You know what? Bo, don't start no jump. Let me see. Realistically, they could have swapped seats and the phone would still be mobile. The position of 10 grid square accuracy is only 1 meter, so that's within 2 seats of a car, I would argue. Okay. Like, I'm really like, I never even thought about it, right? Originally, but that's possible as far as doubt, you know? But yeah, so let's keep going. So we almost halfway done with this document so that we can finally see exactly what's what. But so far, like I said, they're presenting their case to show like most of their evidence is towards Melly. And we know in that trial, it seemed like all the evidence is towards Portland. But all right, let's see. KKK. We already know that much. All right. So they also say right here, starting at line 9 through line 14, is that another reason, again, we've been saying this. They say that Melly's phone and Sack Chaser's phone is together the whole time until Demons or Melly is released on the side of the road by Henry. Now, that's stated like a fact, though, which is like, huh? You know what I'm saying? That's stated by a fact in the case that they said that's what happened. Wonder why they say that happened, though. Let me see what y'all write. Location information, GPS is pretty accurate to determine where everyone in relation to each other. But if they don't have all the cell phone data, that would be harder to prove. And then I got Prince saying, you know that from military land name 10 digits. Y'all be talking. I got you. Okay. Okay. I got 3 feet 1 meter. Although we got a nerd fest in my chat right now. Shout out to Bo and shout out to Prince. See, Bo and Prince, they understand each other's language. I'm over here like meters. What? But yeah. So in summary, what I'm taking is that the phones can definitely pinpoint to a certain degree the movement. However, how do we know without a reasonable doubt that the person they're putting the phone with is indeed the person they're putting the phone with? Will be my argument, right? It's just, how do we know? Because like I said, the same thing we can say as far as, Melly being in that left passenger seat, right? Hold on, y'all. My phone about to die. Let me switch out. All right, I think I'm good. Okay, so the same way, we can say that. We can say the same thing as far as what if Portland didn't stay in the driver's seat? All right, boom, got it. Let's keep going. What is wrong with her? Oh, cry, baby. All right, y'all. I'm skimming through. Yeah, because this is what we saw the last time. Now, again, like I told y'all, transcripts are transcripts. But it does say here, hold on, let me go back up so we can get there. Hold on, y'all, because my grandbaby is showing out and she throwing me off. One second. Can we get her quiet a little bit, please? All right, y'all, I'm back. I done knocked my phone stand down. Hold on. All right. What it do, Classic? I had to walk out. I go tell my daughter to get my grandbaby quiet, and she's yelling. So now I hear her and the baby. Lord. All right. Let me see. All right, let me see what y'all talking about. Let me see. All right. All right. So here we go. It then says the actual crime scene is discovered later after this cell phone search warrants come back was found based on this cell phone data. And it also shows that at the exact time Jamel Demons was outdoor stationary Other than that, he was inside the car at all times. If that don't put fear in you about these cell phones, like, God dang, you know when I'm inside the car and outside the car. Then it says, so this again is showing directly after the homicide is the way they travel back. And then Mr. Demons is released out the car at the side of the road before he's picked up by another individual by the name of Frederick Gibbons, also known as Frito Bain. Then it spells out Bain. Then it says, so again, cell phone mapping. And this is again what shows where they had disposed of the firearms and then went back later on and picked them up later in the day. Now, again, I mean, I don't know how they put Fredo Bang right there, but they got it in this paper. I mean, you can't take that away from it. It's not said at trial yet. It only says that he received the location, so maybe that'll come out later on, or something. I don't know. Okay, they're having a conversation. All right, so now it says. This is when Cortland hearing defendant that we'll hear shows up at the hospital. Okay, we already know that part. All right, so it also says he took time to change during the event. And in fact, we can say that happened after the fatal shots were fired because the victim's blood was found on the front and back of his shirt. And it says, getting into that, this is on his clothing. This was submitted as part of the state's crime scene analysis and information on that, as well as State Exhibit 19, which is the swabs and cuttings from said shirt, in which the front of the t-shirt is identified as item 23, which included blood from Sat Chaser and Juvie, and then item 24, in which that was the back of the t-shirt, the cutting from the rear that shows that Juvie blood was included in that, and Sat Chaser was excluded from that. See here, Mickey. Remember we were saying the prosecutor never saying Fredo Bang picked him up in her opening statement. She didn't. She said it in Arthur hearing. Good catch. Yeah, and I had said that the other night. So I'm like, I don't want nobody to think I'm like biased, but I mean, like, what changed? Because if it was said in 2020, this hearing was in 2020, why not say in 2023? That's a big piece of information if it's really panned out to be information, All right, so let's see here. Now, let me ask y'all something. Has a blood expert talked yet? The blood, what they're called, like the expert on blood, because I'm just saying something here, right? So it says here that on Bortland's shirt, the cutting from the rear shows that Christopher Thomas, which is YNW Juvie blood, was included, but not Sat Chaser. So in my mind, does that exclude him from sitting in that back seat? What y'all think? If the blood, well, it kind of feel like maybe so, because allegedly, right? If he's no, they say it happened from back there. Cause I'm about to say, because if he's sitting, because for Thomas, for Juvie blood be on the back of his shirt, he couldn't have shot him though, right? Let me see what y'all saying. What's up, Jersey? No, they could have wiped the car down. And then it says Prince. Okay, I'm rolling with that math. Makes sense. But Let me read that again. I don't know. Now I'm kind of a little scratching my head. Said blood from. So the front of the t-shirt had blood from both of the victims. And then the back of the t-shirt only had juvie blood. Front of the t-shirt, both of the victims. Back of the t-shirt, just one. How does that happen though? Front of the t-shirt. I'm thinking this through, y'all. Front of the t-shirt. This is a doozy. I can only imagine being on this jury, okay? Front of the t-shirt. Hold on, give me a second, y'all. Let me look up something. What it do, Arthur? Hold on. It says had to be splattered right because the driver's seat was clean. And it said, was it only a spit? Let me read it back again. So it says at some point he took time to change. It happened after the fatal shots were fired because the victim's blood was found on the front and back of his shirt. So getting into that, this is on his clothing. This was submitted as part. And it says this is the swabs and cuttings from the shirt. So it doesn't say right now. Let me see. It doesn't say like exactly where it was. Well, I don't know if he was covered in it because remember they put on the hoodie. So on the video, we can't see the shirt. So I don't know about that one. I'm over here still rubbing my head like, All right. So they get into the glass. They already did that in court. Now let's get into what they think of the staging of how Mr. Henry or Bortland was stating he was sitting when the shot started going off. It says here that, so getting into the actual vehicle itself, there was a trajectory done of the bullets to get an idea of where they were fired because the story by Henry was that this was a drive-by shooting gone wrong. Henry said that he got down and he didn't see anything, didn't know who the drivers were, couldn't identify, couldn't say what kind of car. And he said he plays, okay, we already know that was a lie. They asked his lawyer if he would like to see the photos from the ME. So they're like, no, we don't got to do all that. All right, so here we go. Then they said the blood, as you also notice, is not in the back seat. It is all in the middle of the car because the gravity as well as the state's contention is that these were fired after Jamal Demons had already shot Sat Chaser in the back of the head and Juvie on the side of the head, at which point Juvie is slumped over to his left and the bullet wounds that are here that go on a downward angle match the ones that go across his back. Then it says here, moving to some of the trajectory in the rods that were put in are also not consistent with a drive-out shooting, because you have some that are shown at about 2 feet off the ground on the side of the car, and then others that are coming through and breaking the glass in the back. That's different in terms of the height. Okay. They basically said they did a horrible job with staging this. And it says here, the problem that they have with this one is the passenger door was open. If this was a drive-by where the car was actually moving, the door would have been closed. There's no way the bullet would have wound up in that portion of the vehicle. Then it says also, Melly had been sitting there. When this stage drive-by occurred, he would have been shot through both kneecaps. Then it says, showing more of the interior of the car, it's interesting to note that one that goes through the two headrests, neither one of those entrance or exit wounds corresponds to any of the entrance or exit room of the body of the two deceased victims. And so with regards to the trajectory, it shows that these were coming up at much higher angle than the ones on the side, which brings me to the items that were found inside the car. So far, again, they have video of Melly getting in the left passenger side of the vehicle, okay? They also have a phone registered to Melly, which is in that vehicle with the other two phones, because remember, Portland does not have a phone per the document, right? So they're traveling, they got the movement of the phones. Now, out of everybody in the vehicle, 3 arrive at the hospital, only 1 is living, 2 is deceased. So that 4th person who was sitting at the last time of receipt, right, at the studio was Melly. They don't know what Melly is. To this point, no one has provided a statement to what Melly is or how he got out the car. The only statement that was provided was in the beginning, which they have found to evidence that was a lie. So right now, I can see why the evidence per this hearing is definitely pointing towards Melly as far as against Bortman. Now, I will say here, if you look at line 15, it says, in terms of ballistics report, after George Bello from the Broward County Crime Labs tested those, he was able to confirm that shell casing that was recovered from the inside of the car is consistent and fired from the same weapon as the onces that were found on the side of the road on Pembroke. So again, the photos of the victims' cell phones that were recovered and then searched. And then also we have video of Melly admitting to shooting the individuals in the head. Then they play it. So then we may have to listen to the ballistic person again, because per this hearing in 2020, they said the ballistic person, per the report, was able to confirm that the shell casing that was recovered from inside the car, which was the one in the white plastic bag, was consistent with being fired from the same weapon that they found the shell casings on the side of the road. See what y'all talking about. Let's see here. Bo says this was poorly thought out crime. Nothing matches. If you were Melly, you would have a lot more convincing of a story. If what he said was true, you would have to be able to. Well, let's be honest. Melly ain't said nothing. So this story is coming from Portland, right? Let's see what's next. So Prince says, yes, same weapon and same type of weapon are 2 completely different things. Okay. Let me see. Facts, they should be able to tell mostly if they were shot from the same weapon, but I think they usually need the weapon for that. And correct me if I'm wrong, is that what they stated? The gun expert? Y'all know that was one of my ADD moments. I wasn't focused. All right. So the prosecutor now says, and this is in regards to the video that they played at this hearing, which is allegedly Melly admitting to the murders, right? It says that he says there's no regrets for the ish that I did, including the derogatory that I refuse to use for African Americans. And he then takes the pen and puts it to his head in the shape of a gun, like pulling the trigger, throws up a blood gang sign, and then says he both of them never say when. Then it says, so the interesting part of this video is it was 1 month to the date after the shootings occurred on October 26th. So they then state this video was on Demon's cell phone, which was brought to my office by 100K Track, and that's how we had it. And that was all of the evidence, Your Honor, has before you is from search warrants, subpoenas, and of that nature. There is nothing that was done by consent or anything for that. Hold up. And that was by consent. So I will say, and now I still stand on, I don't understand why 100K Track took that phone to that meeting or even kept that phone, period, right? I ain't gonna lie. But it does say here, right? All the evidence that they presented was from search warrants, subpoenas, and of that nature. There is nothing done by consent or anything for that. So if we look at just that wording, it doesn't seem like Track willfully, right? Like gave the phone. However, he willfully took the phone with him for them to provide a subpoena for, in my opinion, just how I'm looking at the wording of it. Let's see what Bolt said. That's what I mean. Melly said nothing. If he was smart, he would have told as much as the truth as possible to corroborate the story. Oh, gotcha. All right, let's see what's next. Next, they go down to the phone call from Texas. What it do, Ned? How you doing? And remember I talked about this, the Harris County jail call for which Portland calls Melly, right? And during this call, this is what it said. Voice 1, it says, "Hey Mirror." I mean, I don't know what's Mirror, but you know, "Hey Mirror," right? Voice 2, that's not my name. Voice 1, "Make sure you are straight, dude. Make sure you are straight." Now, based off that, Voice 1, in my opinion, is Portland. Voice 2, in my opinion, is Melly, right? So now Voice 2 said, "What you mean?" Voice 1 said, "I'm talking about make sure you ain't got no warrant light." Then Voice 2 says, "I don't." Voice 1 said, all right. I just want to know because I don't even know somebody." And Voice 2 said, "Yeah, but you can't talk about that ish," right? Then it says, Voice 1 said, "Yeah, I'm going to call you later, dude." Voice 2 said, "All right, call me later." Voice 1, "All right, love all." Boom. Again, I don't know why that call took place. I kind of feel like, and this is just my opinion, and I mean, not even on some like they were guilty of something, but I just feel like if it was anything, right, that needed to be understood, you calling for one would make that clear, right? Like you could have called and be like, "Yo, bruh, they got me on something from Florida and I'm out here living in Texas. Stop," right? Or, "Yo, do you know they got me here on a warrant?" And I'm like, "What warrant?" Like something like to like the flow of that call just screamed to me what the okay, because I just don't understand having that type of dialogue on a jail phone call, which is now, guess what, being presented in court against you and the person you call. I just think that's crazy. It's just so many ways that could have been worded for it not to sound Not saying it would have took away the suspicion, but saying something. I mean, you calling somebody that allegedly may be part of a crime you committed would have been enough, right? I ain't gonna say no lie. Personally, you should have called and said your name and hung up. Because I know if it was me, if I was involved in something with somebody, they called me from a jail, I hear their name, I'm not even answering the phone. Okay, I get the drills. Call whoever I need to call. Yo, let's get this together, because obviously something's about to go down, right? Or make sure I'm good or something. Like, that phone call just always did something to me, okay? Just always did something to me. Like, Bo, I just don't get it. I mean, that, from the beginning, that phone call just always was weird. I never understood why it was done. And why even last? I'm not gonna go on that part. Just always like just killed me. Now, and boom, look at line 9, right? And the prosecutor is saying it's interesting that Mr. Henry is worried that Demons now has a warrant. And they make statements onto the fact of, do you have a warrant? Because they are in this together. They are co-conspirators and they are charged as principals. Now, this is my thing, right? Let's just, y'all know, like I said, we're gonna do, make sure everybody know. All right. So basically, a principal is basically your equal in this, okay? You work together to commit this crime. So, in this case, if we are co-conspirators and we are principals, based off this phone call, according to the prosecutor, why are we not charged as such? Because I don't see it as principals, but they're saying they are principals, right? Hands of one is a hands of all in so many ways. If they're principals, right? They're in this together, she says. All right, now it says for the other evidence that has been brought forth between the cell data, the records, and everything else, the state believes that there is proof evident presumption great to hold Mr. Henry on these charges. Then it says there is no special exception for principal or that he wasn't the shooter that prevent him from being held under these facts and circumstances. So to me, they just flat out said he's not the shooter, right? But they're saying there is still shouldn't be an exception because he's a principal along with the shooter. Now, it says the state's relying on exhibits that I've provided as well as my written motion on that. And at this point, the state believes I met my burden and whatever the defense has to say. Okay, now we're getting into the defense part of the hearing. And it says this: everything they have presented shows nothing other than his presence. They don't say whether or not when those cars are boarded that there had already been a shooting. They don't show anything showing a shooting was planned. They don't have anybody to say that. They interview, I don't know how many witnesses, listen to how many phone calls. Based on every single thing, there is nothing to show that he had any participation in this shooting other than the alleged shooter may have blown 2 guys' heads off in the car for no reason. Let's see. The investigators and state fumbled this case for sure, definitely. Arthur says the judge here, Melly murder on my mind. And you know what? I hope that is not what he does because that song is not even relevant to it. But you know what, Arthur? All right. So then it says they got into their car and what is apparent from the video in a friendly mood. There is nothing to suggest at the time that they were at the recording studio there was any hard feelings amongst anyone. To say that other individual overpowered these individuals or whatever is contrary to the evidence they have. Then it says the statements they took shows that, in fact, the gentleman in the front seat was domineering individual to Mr. Demons and controlled him through his mother, did all kinds of other things, which I'll show when I present my case. What the hell does that mean? What it do, cat? What does that mean? Did y'all catch? Like, what's what? It says the statements they took shows that, in fact, the gentleman in the front seat was a domineering individual to Mr. Demons and controlled him through his mother, did all kinds of things, which I'll show you when I present my case. Okay. There is nothing to show that as these people left that house, that recording studio, as they drove, anything was planned. There is nothing to refute that whatever the shooting was done. He was covered with blood, supposedly. There is not a single, what is that? Scintilla of evidence to suggest he did any shooting. The state doesn't suggest it. They have their ridiculous theory of conspiracy because he asked on the telephone, because as everybody knows, they were together. They were 8 people saw them together. Do you have a warrant? He is the person, and he's a very smart kid, who drove these people to the hospital, did what he did, talked to the police, gave a statement to the police, misleading as though it was. There's nothing to show that he had any attention, participation, or anything in the killing. Then it says the prosecutor can argue anything she wants about principles, but when you read all the evidence in this case and all the documents, which I know you have most of them, there is nothing to suggest he was anything but at best an accessory after the fact. Let that sink in for a second, okay? Now, it then says, they have not a scintilla. Is that scintilla of evidence to show he planned participation? I think I said that already. They put in all their fancy cell phones, light that helps me and us more than it does them. Okay. It shows that he's there. They are there. The other defendant leaves the area and goes in another car and takes off. He takes the people to the hospital. He does what he does. He gives a statement. I agree, for purposes of this hearing, they can say he gave a statement, but that does not make him a co-conspirator in a murder. To be a conspirator or a participant in a murder, as you know from the conspiracy law, you have to have at least be part of the plan. You have to have some intent for this to happen, anything. And they have not a thing to show that he had anything to do with this murder other than accessory. In the light most favorable to them, a accessory after the fact, which is a second-degree felony, I believe, or even if a first, but it's a second-degree felony, he's entitled to a bond as a matter of right. And then it says, I was going to order the transcript because that's what they are showing. So I'll ask that we bifurcate this. God dang, what the bifurcate? I think that's how you say it, bifurcate. Let me get the transcript. Okay. All right, bam. That's it. That's a lot. So, that was a lot. So before we move on, because I know the chat is like, yo, that's a lot to take in, right? So before we move on, let's just like take it in, because that was a lot going on. All right. So for the most part, they basically said, hey, ain't got nothing on us, okay? Nothing on them. All of the information that was provided was against Melly, not him. He at best is accessory after the fact. All right, I see y'all questions. Give me 1 second. I'm gonna answer them. I got to scroll. Y'all was typing fast. All right, so this is the next document in regards to the Arthur hearing. Okay, and it says here the defendant is providing to the court Exhibit A. And then it says it's a transcript, which we just went over. It says here the court had the benefit of hearing the state's theory of how, in its estimation, the proof was evident, the presumption great to degree above beyond reasonable doubt, is an effort to deny Mr. Henry release. Then it says, however, all due respect to the very able prosecutor, Miss Christine Bradley, the evidence to even suggest to deny bail was so underwhelming as to compel this written response with the request that bail be set forthwith. So, I mean, Portland's lawyer is like saying, the prosecutor ain't got nothing. Okay. All right. So basically, they just went. Hold on, I don't want to miss that. So hold on. Oh, now listen. Now look at this part. Okay, it says the exhibits presented, including the gunshot residue test, the stick trajectories of the travel of various projectiles, the video and audio played, the cell phone site location that show the positioning of the individual make clear the defendant never fired a weapon, nor does it appear anything was ever planned. Wow. Did y'all get it? So his defense at the time, he never fired a weapon. So how do they have gunshot residue positive for you at Melly's trial? Now it says, while circumstantial evidence is admissible and worthy of the consideration, this is crazy that too singular favors the defendant at least as to release. There is just no evidence in any way suggesting the defendant was involved in the alleged murder. Yes, something. So basically saying that any ill will that they had was between Sat Chaser and Melly, right? And it says the statements made somewhat clearer. The front seat passenger, Sat Chaser, was rather controlling, overpowering bully. Now this is in Portland's documents, not Melly, okay, so far. Like, this is what they're saying, right? Oh, Lord, this is a lot. Then it says, from the vehicle trajectories, from the cell sites, and so forth, a reasonable explanation is that something occurred in the vehicle that Sat Chaser was riding in that caused a rather rapid reaction, but not by Henry, and that's underlined, okay? And it said it appears what occurred from all the evidence is a spontaneous outburst. The state showed nothing, and there is absolutely nothing to suggest otherwise or to in any way implicate Courtney Henry in this shooting. The shooting, by all evidence, occurred from the rear left passenger seat. Mr. Henry was the driver. Then it says, while the state may have an arguable accessory after the fact claim to present to a jury due to Mr. Henry driving to the hospital and perhaps a rather erroneous statement of what occurred, that does not remotely, under the facts of this case, translate or transfer to a charge of felony or premeditated murder. Ooh, this is a lot. Now, all right, I'm gonna read this one, and then we're gonna keep. Okay. So then it says, the undersigned has attached to this reply the transcript of the hearing had before this court on August 23rd, 2019. So this was 2019, not 2020. I said that earlier. And quite clearly from a reading thereof, the only matter left to determine is the amount of bond the court ought to set. The defendant submits that based upon the showing the state made, if that be the that's a lie. Okay. So let's go to now. I want to show y'all something that just caught my attention just now. Like literally just now. So we know about this Arthur hearing, right? August 23rd, 2019. But what I didn't know until literally just this moment is that another Arthur hearing took place October 17, 2019. Is no transcripts filed there. So let me click on everything in between the two dates because let's see. So this was a motion of discovery. What's in here? It says the following records will be introduced via certification. And that is Facebook, Instagram, names there. Okay. Let me see next. Let's see what's in this one. More business records, affidavit for Snapchat, Facebook, Instagram. Now, one thing I want to point out right here. Hold on, let me see what y'all been saying. Set chaser was this Art Melly. Okay. So what I want to point out here, let me make this a little bigger. But it'll take a while to get it. But statement, Jameson Francois, May 10th, 2019, 32 pages. So Francois is a 100K track. I will be interested in knowing what he said in his statement. So I'm going to request it. Probably going to take a little bit. I have no idea who Mookie Guap is or Brackwoods. Don't know who that is either. All right. And then it's nothing with it, right? Hold on, let me see what this says. So notice of hearing is for Cortland Henry. It's a continued Arthur hearing. Interesting. That's interesting. Why would the transcripts from the first one be there, but not the second one? What happened in that second hearing? So what we have here, so the notice of hearing for that second Arthur hearing was submitted on September. Okay, Kat, was on September 24th, right? A hearing was held for change of plea on September 24th also. But it's no documents to those two. Which one, Prince? So this is what we were just at. I clicked on that. This was the one for the Arthur hearing, right? Then on the same day, a change of plea. Arthur 8. Yeah, that's the one we just read. That's the one right there. The transcript that we just read was the one from this one. So it was one held on August 23rd. The transcripts are there, right? Oh, and I see why they're there, because the defense put them as an exhibit. So those transcripts that we just read was put into on record by the defense. However, the next one is not put into by the defense. I would love to know, what in the world did it say? For sure. I definitely would have wanted to know that. All right, so let's get into this real quick. So this is the discovery, and it says 3 discs of additional jail calls. And then, okay, so here go the order of the Arthur hearing. All right, y'all, give me 1 second. I'll be right back. All right, I'm back. All right. So let's see here. Oh, my feet are cold. And before we get into it, make sure y'all like, comment, share, subscribe, tell a friend to pull up. We are into the documentation, what we do best over here, okay? Now, let's see. Now, they said, now, based on this document, right, it's saying that based on the one that was done October 17th, 2019, for Arthur hearing and the court having read the defendant's motion to set bond and memorandum. This is all they had at the time when they made this decision, okay? They had incident reports from the police department, incident reports from the crime scene unit, statement from Henry, sworn statement of Mariah Hamilton, who is the girlfriend of YNW Melly, sworn statement of Nakia Bagley, don't know who that is, sworn statement of Trayvon Glass, which was one of the riders in the second car, sworn statement of Kanisha McCarter, don't know who that is, sworn statement of Andrea Scott, which is the wife of 100K Track, crime scene photos and vehicle, Courtland Henry at the hospital, crime lab processing report of Courtland Henry clothing. So one small little question, y'all. If they process the clothing, why didn't they test the clothing for gunshot residue? Because remember, they didn't test the clothes for the gunshot residue. So, but if they processed them, how they didn't get tested? Then it says crime scene photos, trajectory search warrant, RJ Lee Group gunshot residue test results, BSO crime lab ballistics report, surveillance video from recording studio, Sunset Lakes, Monastery School, Snapchat records of Jamel Demons, crime scene photos, US 27 and Pembroke Road, jail calls of Courtland Henry, Houston, Texas, jail phone distraction, Jamel Demons, crime scene photos, processing evidence from vehicle, BSO crime lab, DNA report, cell halt, cell data, call data record mapping, cell data records, T-Mobile Jamel Demons. Hold on. And Anthony Williams, having read the defendant's response to the state Arthur presentation, having read the transcript of the Arthur hearing, having set a status hearing to obtain additional information necessary to review documents and recorded presence by the state in the Arthur packet, having heard argument of counsel for the defendant, having heard argument of counsel for the state, having reviewed the applicable law, and otherwise being duly sworn in the premises, the state of Florida has not met its burden of proof, evident presumption, great based upon all the evidence presented at the hearing and the documents and other information submitted to the court as to the charge of first-degree murder at charge in the indictment. Whew. So, now, what does this mean? Well, this means now, instead of being on a charge that cannot get bond, he can now request bond because they have found the state did not meet the burden of guilt or, showing that is guilty or whatever. Oh, that was a lot. So let me ask y'all this. All these statements, all these tests. So if the judge felt like the burden of guilt was not on Portland, does that mean all this information is supposed to point towards Melly? Or what y'all think about that? Y'all know. All right. Let's see here. Yep, they pointed at each other. Let's see what this is about. So this is filed for the family of YNW Juvie. And I will say this is filed on behalf of both defendants because it's on Melly's case also. And basically it's their rights to be a part of the trial and, to have their voice heard and what they feel should happen or their stance. And I'm be honest, their stance happen, they don't want neither one of them out. Now, this was filed on April 23rd, 2020. This is the motion for motion for hearing on release. Okay, I'm not going to get too much in this document because it gives personal info. I forgot about this one. All right, so basically this was where they basically submitted all their documentation, like that he would have a place to stay. He will have, all this, all that. That's what that's about. But I'm not, like I said, I'm not going to show it because of the information that's on it. I don't know if that's still accurate information. Pretty sure it's not, but I'm not going to show it. All right. Now, here go another order. And this was for another Arthur hearing. And this one says it was heard on February 28, 2020 and May 21st, 2020 for the purpose of setting bond. Then it says here, the court heard the defendant's mother, having carefully observed and weighed the credibility and demeanor of the witnesses and this and that, they finally set bond. So I guess it was levels to it that when they finally got the okay to move forward with bond, then they had to hear from family members and stuff. So prison, not really. They both could have done the same at different Arthur hearings because it would have been the same evidence against them, only the argument. Well, we're gonna look, but I don't believe YNW Melly did an Arthur hearing, to be honest. But we're gonna double check it, but I really don't think he did one. Why he didn't do one, I don't know, but I don't think it's one on file for him. All right, let's see. So bond was finally posted on June 26, 2020. Now, we have determined, and y'all correct me if I'm wrong, the reason why YNW Bortland was released on bond was because he submitted a request for an Arthur hearing. Judge Siegel determined the state did not prove their case in regards to Bortland, so he was able to then request for a bond. And after requesting a bond and securing what he needed to secure as far as a place to stay and everything, they let him out. Are we in agreement on that so far? And I will say this. Yes, Bortland did violate his bond for going to a nightclub or a strip club in Miami. That is correct. That is on file. But they did let him back out. And we'll get to that. Any questions, y'all, before we continue on? Let me see. Let me check the stats of the live. So let's see. We had about 102 people come through here. About 17 concurrent viewers, meaning the ones who've been here since the start of my live. Shout out to y'all. I already know that's the Truth Team members. What it do, Loud Pat? I appreciate everybody. Now, we only got 17 likes. Well, now we got 18 likes. I'm going to need for y'all, when y'all come through and watch it, just hit that like. Like Music said, it's free. Do it for me. I like when you say that. But yeah, definitely hit that like. Shout out to the Truth Team, man. We're going to ride this thing on out. We are now, I feel like we just established why Bortland got out, right? At some point, we may get more, but so far, we at least know why he got out. And I mean, in my opinion, it don't look fishy to me, right? Because we looked up what an Arthur hearing is. Multiple Arthur hearings was done, and I mean, if according to the judge you met it, then that's what it is. We about to get into that one now. Shout out to our future Truth Team attorney Prince in the building. Okay, Prince was like, yo, I just seen that. Who that is? What that paperwork is? I love it. All right, let's see. Did I move past it too much? I think it's further up. There we go, right there. All right, let's see. Now, this particular document has both of the defendants on it, Cortland and I keep saying Cortland, but Bortland and Melly. Okay, so this was done on the behalf of the family of YNW Juvie. Now, I don't know if y'all recall. Shoot. I don't know if y'all remember. It came a time where Melly switched lawyers, right? And it was this whole situation on social media about some of the stuff that Melly lawyer said in regards to some of the details of the case, right? And that the victim's family Because like I told y'all, it is an open civil case in regards to this for both deceased victims. They were trying to get information from each of the defendants, but their stance was it's an open criminal case. We don't want to, say anything right now. Wait till when it's done. But the lawyer shared some stuff that he shouldn't have shared on Twitter. And that's what we about to get into. All right, let's see. So it says here, right, that they request to prohibit the release of that certain video or recording allegedly from the phone of Jamel Demons bearing the date of November 26, 2018, because Mr. Phillips has shared information about this case on his Twitter account. And it says here, victim and victim's counsel state as follows. It says, on October 2nd, 2020, Jamie King, the mother of defendant Jamal Demons, filed an inquiry with the Florida bar allegedly Attorney Phillips has falsely made prejudicial and God dang, y'all see it, shoot, that my son Jamel Demons recorded an admissible of double murder and that the alleged admission is in the court file. So this is regarding that same video that they played at the Arthur hearing that was filed in the phone that was subpoenaed from 100K track. It says, Jamie King references a reply Mr. Phillips made to an apparent fan of Mr. Demons who was chastising Mr. Phillips on Twitter. Phillips said he recorded an admission of it and his phone records put him at the scene. Read the criminal file. Some of it is there. Yo. They said this is Melly's lawyer saying this, right? Let me make sure I'm right. So hold on. I need to make sure. I don't know who Attorney Phillips is then. Let's just put it, so I don't know at this moment. Maybe it's at the bottom. Who Attorney Phillips is. I don't know who attorney that is. I thought maybe it was Melly's lawyer, but maybe it's one of the family's lawyer. Not sure. Oh, here we go. It says Mr. Phillips does not represent any party to the criminal case and otherwise has not released any information about the case or otherwise caused any precedence to the case whatsoever, nor is same alleged. So basically, he was just a regular attorney, I guess, looking at the information, putting it out. Now, I don't know the stipulations for attorneys to do stuff like that, but this is the basis of it. Now, it says, based on the need to file a lawsuit because of the pending statute of limitation running on October 26, 2020, and in response to the bar complaint on October 14, 2020 at 2:07 p.m., on behalf of Christopher Thomas Jr. and myself, because of the bar complaint, we requested of the parties to the criminal case, can I get a copy of the transcript or recording of the omission of statements made by Jamel Demons? Now, in my opinion, we know, right, based on what's in the discovery, Jamel Demons didn't provide an actual statement. However, what we do know, per the Arthur hearing, is that a video was discovered out of the cell phone provided by 100K track, which is supposed to be Melly's cell phone, that had a video that was recorded about a month after the murders that said indirectly he admitted to killing his two friends. Right around. That's where we at with that, right? So it then says Prosecutor Bradley requested more information stating, good afternoon, Mr. Phillips. I am not aware of any audio or video recording. So if there is something more concrete to narrow the scope of what you are looking for, that would certainly be helpful. This will have to go through public record. So I will forward your request along to them. And I'm going to tell y'all, just from personal experience, because y'all know I have talked to Mrs. Bradley before. She will talk to you for sure, right? And she will refer you to public records, okay? For sure. Now, from my personal experience with Prosecutor Bradley, is that if it's by phone, let me see, how did they talk? I'm assuming since they said good morning, maybe it's by email. I know by phone, she actually looked up the information that I was asking about, right? By telling me the date, how it was recorded and how to, of course, get a copy of it. So, I don't know. Let's see. Then it says that Mr. Phillips responded, I am referring to the video recording discussed here. Phillips attached a portion of a public transcript where Prosecutor Bradley stated, and so again, the photos of the victim's cell phone that were recovered and then searched. And then also we have a video of Mr. Demons admitting to shooting 2 individuals in the head. So basically, this is the Arthur hearing that we just went over. Okay, so everything again that was said in that Arthur hearing is coming tenfold. Now, it says that on October 14, 2020, the state attorney said, we are in receipt of your request for public records. Please be advised that due to the ongoing global pandemic created by the COVID-19, it's going to be a delay in response only. Okay. So, let me see what else. Says on October 27, 2020, defendants filed this motion and objected to us receiving certain videos or recording alleged to have been made by defendant Demons and in the possession of the state of Florida. And it says there that one tweet by Mr. Phillips urging for peace and justice. So, I guess this is a lesson, right? Because, and this is a lawyer that's doing this, how a lawyer just putting something out, just talking, just really talking about it, right? Is now causing a uproar because now the family is like, oh, we ain't know about this video. Where is that, right? Or this lawyer wanted to see the video, and I believe the video has been released so far too, if I'm not mistaken. Hold on one second, y'all. But, my mouth got dry. All right. Now, it then says the state of Florida has a right to rely on a host of protections to avoid release of information. And Mr. Phillips has previously expressed an inability and desire to execute confidential agreements on any information which could be deemed sensitive. However, this motion seeks to stop only him from possessing what is otherwise public information. It says further, the request is coupled with a restriction on speech. A request for a gag order of this type is not appropriate, particularly in light that Mrs. King is seeking to reprimand Mr. Phillips, claiming he resorted to a false characterization of the evidence presented in court, which is contained in a public transcript available to all. Right. Now, I will say I agree with it so far because we literally just read this transcript that's been on file since 2019. So, I mean, if anything, maybe just like a lot of the other transcripts, including like Fredo Bang, maybe you should have requested it not to be published online, right? Maybe you should have requested it to be sealed. But to say that the guy is putting out false stuff, I mean, that's exactly what the thing said. I mean, I don't know about where the tweet at, but that's exactly what it said. We just read it. she flat out said, boom, 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 right? She said it word for word what was allegedly in the video. I'm eating candy, y'all, my bad. All right. Hold on, I gotta eat this real quick. I think I'm gonna open the panel. So hold on. And yeah, it's good. All right, I'm gonna open the panel so I ain't gotta be the only one up here talking. If you want to join, pull up. Let's talk about it. So I can have time to eat my Laffy Taffy. Oh, it's not even Laffy Taffy, it's an airhead. All right, I'm almost done chewing. All right. So while we wait to see if somebody want to pull up, we're gonna keep going. All right. So, here we go. It said, in contrast to Mr. Phillips publicly urging for peace and justice, and another urging interested people to check the court file, the defense team and Mr. Demon's family have engaged in constant narratives to claim that Mr. Demons is falsely accused, will be free any day, and otherwise use the COVID-19 pandemic to publicly victimize Mr. Demons. So basically they're saying like, yo, that ain't cool, you know? I don't even, you know what? I do think I remember back then it was a lot of free Melly, or Melly will be home soon, I think, if I can remember correctly. Y'all moving slow. Nobody want to come up? All right. So let's keep going. So then it says that a lawyer change did come off the case July 1st, 2019. Oh, here we go. Then it says Mr. Cohen's, which is the lawyer that left the case on July 1st, 2019, goes by the name Law Ronin on social media platform Instagram, and posted a motion he filed after his withdrawal, which included a screen grab of his motion with the following commentary. It says, I have filed a motion on behalf of Jamel Demons to have him released to a hospital for any treatment necessary for his diagnosis of COVID-19. It is a scary situation for all inmates in the jails, as I believe most jails think they can handle this outbreak. And my opinion is they cannot. They must loosen the regulations on soap, hand sanitizer, and wipe. They currently are banned because of the alcohol content. Okay, and then keep going. All right. So it shows that, and he posted, okay. Okay. So they got a lot of evidence up in here. Even when it posted on like newspaper. Then it says here at number 15 that Cohen's also posted on social media. This will be interesting trial. I am not longer representing Melly in this matter, but I predict a not guilty based on all the evidence I have viewed. So I mean, his lawyer in 2020 at the time said at that point they ain't have no evidence. That's something. That is something. Then it says, since then, he has told media, in terms of the evidence that I've reviewed, I think there are some substantial questions and substantial areas that I think are very large holes for the prosecution that they're going to have to fill And I think that benefits the defense of Melly. Then it says it's not just Mr. Cohen spreading information on a criminal case. According to Complex, on March 12, 2020, it says, through lead attorney Stuart Alderston declined to comment, another one of his lawyers, Raven Romana Liberty, who also represented Florida rapper Kodak Black, alluded to the cryptic and now deleted 313 post that appeared on Demon's Instagram account earlier this week. Big things are going to happen tomorrow, she said, perhaps alluding to the release of a new collaboration with Juice WRLD. Liberty also noted Demons and the other inmates at Broward County Detention Center where he's being held have been in the dark about the coronavirus pandemic as of recently on Saturday. They know nothing. There isn't any sanitizer or anything, she added. The same article quoted Mr. Henry's attorney saying the proof against Mr. Henry isn't that strong. His attorney, Fred Haddad, told Complex ahead of Wednesday hearing, my client is not guilty, period. Then it says, meanwhile, the actual defendants here involved in a free Melly movement, including selling and asking people to sell free Melly shirts, releasing posts and videos on all their social media accounts to millions of followers, otherwise engaging in a narrative which is contrary to the known evidence in the case, but which has led to the threat of violence against the undersigned. See below. Wow. All right. Dylan. Oh, shoot. What the world? I'm not going to repeat that, but that's something. Whoa. Whoa. That is something. All right. That kind of threw me for a loop just now. So this includes additional public communications between the two defendants. Now that defendant Henry has been released, in a recent post to Mr. Demon's personal verified Instagram account, YNW Melly posted, "A slime, what it do? YNW Portland, Bort home. I'm on my way, B." And then it says Melvin, which included a photo of co-defendant Mr. Henry posing on a Mercedes. And I just want to point out, in my opinion, right, I never feel like, hold on, let me rephrase this, because up until recently, I never felt like those pages are actually ran by the person, right, when they go to jail. I honestly felt like it's ran by their team. Now, recently, I have come to know that that's not always the case, but in the case of Melly, I definitely, in my opinion, don't think it's him running the page because, as I told y'all on my last live, when I attempted to reach out to YNW Melly back in January, when I first started looking at his case, I got the notification back that he's not able to even communicate by mail. He wasn't able to have phone calls. He wasn't able to use email, like none of that. Now, if he's able to send outgoing mail, I don't know, but he cannot receive incoming mail for sure. So I definitely don't think he's running his social media. So with that, who do I think is running his social media? Possibly his manager or management team. So, I mean, to put that in there, I mean, we know allegedly, right? Possibly that's not him writing it. But nevertheless, that's what they have in here. And there go. It'd be so crazy. Just a little side note. It'd be so crazy with these cases. How many times I see actual like screenshots of social media. All the time, it's always included somewhere. right. I do remember seeing those t-shirts. And then it says that defendant's mother, Jamie King, is publicly active and vocal about the alleged innocence of her son. So it said, it appears counsel is seeking an excessively overbroad, highly irregular, and entirely premature injunction against a gag order and or prevention of Mr. Phillips, the victims, and or the public from receiving records which would otherwise be considered public records, restraining free speech, and otherwise withholding information from the public while their team simultaneously seeks administrative prosecution of Mr. Phillips with the Florida bar. So basically they're saying, yo, this is public information. Y'all pushing it. People can see it online or whatever. It's not against the law for them to read it. So then it says here, oh my gosh, my grandbaby just always, yeah. So basically what they're saying is that nothing that is being said by the lawyer is doing anything to Melly or Bortland, right? Because again, all of this is public. It doesn't take a rocket scientist to do it. You know, anybody can pull it up. And one thing about Florida, you don't even need an account. Like a lot of places like in Georgia, in Texas, California, you got to have an actual account to pull up things. But in Florida, you do not. Well, not in this county at least. Let me rephrase that because I haven't looked in every county. But Broward County, you don't need to log in. You just pull it up. All right. All right, so that's basically that. So they was trying to basically get the lawyer guy to just stop talking about it. What is this? This is affidavit for failure to comply. Okay, so earlier y'all was asking about Bortland violating his bond. Well, here we go right here. It says these are the conditions violated. It says violation of condition 15, pretrial services agreement by failing to remain confined to his approved residence 24 hours per day unless approved by pretrial service staff, and that in Broward County, Florida on 3/27/21. The defendant was given permission to leave his residence for work. The defendant was tracked to a private residence in KOD Bar and Club. Then it says on 3/28/21, the defendant was given permission to leave his residence for work. The defendant was tracked to Playhouse Gentlemen's Club and to G5 Gentlemen's Club. During the time that the defendant was away from his residence, his activities were unknown. I mean, well, dang, you out by the skin of your teeth and you at the strip clubs. What it is. All right, let me see what's next. Now, this is what, okay, so violation, it said arrest papers, right? And I'm going to click on it, but I believe it's because he violated. What all they got on there before I show it? Okay, I can show this. So basically it shows violation of PTR. So that's what this is for. And I just read it. So yeah. This is when he violated. All right, what's next? Now, that was the violation was on, he was arrested on April 15, 2021. Then he had a couple of hearings. Okay. Then on August 25th, 2021, bond was granted again. Now, I showed this because this is no longer address. That's not it no more. But yeah, this is, he got out again. All right. Now, so far, I mean, what I take from all this, as far as on Bortman's end, it was no evidence toward. Now, I'm still confused to why they said he ain't had no GSR, but at Melly's trial, they're saying it is GSR. So maybe, I mean, 2018 to 2020 though, 2 years and you ain't have that. I don't know. That's kind of weird, but nevertheless, that's what they say. Let me see. All right, and then I want to point out something to y'all, and just pay attention, okay? On this case, just look in this area over here, like on the far right. All right, y'all see them low numbers? That's meaning how many pages is each document. Y'all see how low the numbers are? Okay. And I want to point out something else. Do y'all see anything that says deposition? Okay. These are the only 2 times deposition is put. Okay, I want y'all to remember that. Now, if we go, so we're done on Borton's case. If we go over to Melly's case, right? My mouse be acting crazy. All right. Yeah. I spelled it wrong. That's why. Well, hold on. Let me go back to prove what I'm trying to show something. Hold on. I was spelling it wrong. Y'all could have told me that. All right. Let's go back. Go back. So we back at Bortland. Y'all see that? We're back there. All right. So it's 2 depositions listing, right? Let's see who they are. Christopher Robinson, and then Christopher Robinson. So both of the deposition listed is just somebody named Christopher Robinson. Who Christopher Robinson is, I don't know. But I just wanted to point that out. So we go back to Melly case. And then I got a question for y'all once we do that. All right. That's child hell stressing me out. All right. So 2 depositions on Bortland's case, 64 on Melly's case. Does anybody know why it would be 64 depositions on one defendant and only 2 on the other defendant? Does anybody know why it's that? Anybody? Everybody? Because I'm going to be honest, personally, I can't really tell you why. right? I don't know why it would be that much of a difference. But it's a definite difference. As early as January. Y'all don't hear me either. I don't know. That's a big, big leap. Like, that's a lot of deposition. GTS said somebody talking. And it seems like they will be talking just on Melly, right? If it's only listed on his side of the case. Which is kind of, iffy. So what I want to do now, before we get into everything on Melly, let's talk about something real quick. Let's talk about the mistrial itself. Matter of fact, let me see. Let's see. All right, so let's look at this first. It's only about a minute long. What is a mistrial?
A mistrial can happen for many reasons, but let me first share what a mistrial is. A mistrial is where trial ensues and it begins, and for some reason, something happens to where a verdict cannot be reached. This can happen in a civil case, just like it can happen in a criminal case. There could be many reasons why a mistrial happens. Maybe the prosecutor did something that was not proper, or maybe the defense did something that was not proper, or maybe the plaintiff did something that was not proper, or even better, maybe the judge did something that was not proper. Anytime something happens in a particular trial and it is not proper, either party can move for a mistrial, where they state this trial should start again because of some reason.
Is there a term you want more explanation about? Leave us a comment.
I think that was pretty simple. Now, I misspoke just now. So the word deposition was stated 64 times. However, and by looking back at it, I'm going to show y'all, it says defense notice of taking deposition. So no, it wasn't 64 different depositions. However, it's listed way more than on Borton's case. Okay, so I want to clarify that. Thank you, Prince, for stating that, because that made me have to rethink how I said it. And what we're going to do is look at who was supposed to sit down and do a deposition. Because we all know, normally, right? And you know what? Before I do all that, because I want to, without any doubt, hold on. Hold on, let me see. A second. All right, let's look at this.
And I'm an attorney at Cersei, Denny, Scrolla, Barnhart, and Shipley. I'm here today to discuss with you depositions. A deposition is a pre-trial testimony that is given under oath. During the deposition, the opposing attorney will be asking you questions and you will be answering them. The court reporter will be recording the opposing attorney's questions and also your answers. The purpose of the deposition is for the opposing counsel to find out information that you know about the case. There's a saying that you cannot win your case in a deposition. but you can lose your case in a deposition. If there's something that you are worried about or concerned about that are going to be asked during your deposition, it's important to talk to your attorney before your deposition to discuss this with them so that your attorney is aware of the situation before the deposition occurs. A deposition could also be videotaped as well. So if you are videotaped, it's important to be mindful of that and know that any kind of body movement is going to be recorded. So if you're like this and cutting yourself off, it's going to come across on the videotape. If you're rolling your eyes and doing like this or wailing your hands, that's going to come off on the video camera. So it's really important if you're videotaped to think about that and to be mindful that you're being videotaped and recorded. If an attorney knows of something ahead of time, it's much easier to handle it at the deposition when you're aware of that rather than occurring during the deposition itself. So it's important for you to let the attorney know if there's some issue or some concern that you have or something that's going to worry you about the deposition before the deposition occurs.
I think
for the attorney.
That's the gist of what we need. So if y'all remember when Felicia Holmes was on the stand and they were having a conversation about the 2018 statement made to the police and the 2022 deposition. And remember, the prosecution was trying to get the witness for perjury. And a judge specified that as long as her statements hold true from her deposition, then the 2018 statement to the police is just that, a statement to the police. Is not a sworn statement. Let me see if I can just find just that particular part because I want to make sure I worded it right. I think I did it in the way he said it, but just to make sure, you know. Let me see if Law and Crime got just that part. I don't think they got just that part. I can just dang it. All right. I think this is a good place to start with this then. And then we'll get back into it. Hold on. Soon as the commercial is up.
Not a surprise for a defense team, but this one seems pretty serious. What's your take?
I think it is very serious, and
I don't want that.
And that it wasn't accurate.
Okay, maybe we'll do this one later. I thought that was something else. All right, so now let's get back into who all provided depositions, because to me, as we're getting into discussing what a mistrial is, right? Or that's what we should do. Hold on before I do it. I just thought about what we should do before we get into the information. Because so far, what we have as far as phone records, the phone records are providing a lot of details to this case, right? However, what they're lacking is someone putting that phone directly into Melly's hand without a doubt, right? Now, we definitely can assume that it was in Melly's hand because guess what? We saw him get in the car on the video at the recording studio. However, we don't see him in the car once he gets to the hospital. But the prosecutor has provided that phone is still in the area of the alleged shooting, and it's leaving a little, a little thing in your mind. What's up, voice box? That maybe the reason why we don't see Melly in the hospital video is because he's with the phone, right? So on the defense side, they need to show us how that's not what's going on, right? Then on the other side of it, right, is there a witness stating that it is Melly with the phone, right? That is on record saying it. Now, so far we have heard from Felicia Holmes, which is the mother of the girlfriend. Now, if we recall her statement, which we may do a little refresher of that in a minute, she states some discrepancies in what she originally stated or that they alluded to in her original 2018 statement. So we're going to get into that one in just a minute as we prepare for tomorrow's hearing, which I will be streaming live starting at 9 a.m. Eastern time. And in the meantime, make sure you like, comment, share, subscribe, tell a friend to pull up. We is breaking it down so that we, the truth team, have the clearest and best understanding possible as we start off week 2 of the YNW Melly trial, or possibly the end of the YNW Melly trial if a mistrial is presented. So let's see here. Before we get into the deposition, trying to see something. All right, so I want to watch one more video, right? Hold on. Okay, I hope this one. Okay, so I'm gonna play this video. If it doesn't give us what we need, then I'll find another one.
After will your case be retried? You want to learn the answer? Come join me as I share with you this great information. Hi, I'm Jerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. The answer is it depends. Let me give you an example. Many years ago, when I was a defense attorney and I was representing a resort in the Pocono Mountains involving a gentleman who got injured on a sled in a sledding accident. And now I kept referring to this sled that he was on as a pie pan, as a pie dish. It was nothing more than a flying saucer, one of these circular things about 30 inches in diameter. And the judge clearly...
I don't like that one. Don't like that one, sir. I kind of want to hear it. Maybe this one. Let's try this one.
Hi, I'm Texas attorney Dan Lazarine. Let's talk a little bit this morning about a different topic, mistrials. What exactly is a mistrial? When does it come about? And what happens after a judge declares a mistrial here in Texas? Generally speaking, a mistrial occurs when a jury trial doesn't end in a satisfactory manner. So most juries...
God dang it. I want to try to get the state right because I don't know if it will determine. All right, so this is another case, right, in the same county. Let's listen to this first, and then tell us what we need. Trying to understand it.
Breaking news about the trial going on in Plantation. A Plantation man accused of killing his former girlfriend's new boyfriend. The judge in the trial of Eric Robinson has just declared a mistrial after a witness discussed a past restraining order against Robinson. The court previously ordered that none of Robinson's previous domestic violence allegations would be discussed at the trial. Now, according to prosecutors, when Eric Robinson got out of jail in October of 2017, he learned his ex, Isabella Tangolini, was dating a new man, Nicholas Wilcox. He's then accused of going to their home in the middle of the night and beating that man to death. We're going to have more on this breaking news story as it comes into our newsroom.
Okay, that wasn't what I thought it was gonna be. Maybe I'm not gonna be able to find what exactly I wanted to hear. I wanted to hear. This is. All right. I was trying to find us something like that can tell us the pros and the cons of a mistrial. However, I'm not seeing it, right? So we know what it is, but I'm not finding a video that can break down exactly what we can expect. Because, that's the next leg of the live is to determine, in our opinion, what would be beneficial, right? I think that was in Georgia. All right. Shoot. I really wanted to get that up there. Maybe we should just listen to what they was talking about. They just be talking so much. All right. This is what I'm going to do. I'm going to play the video where they talk about the mistrial. And then in that time, maybe that'll give us at least the grounds they're going to do it or possibly do it. And we can hear exactly what's going on. And then in the meantime, hopefully I can find out exactly the pros and the cons of it. If not, again, we're on the internet. We're just playing Clue, but I would prefer us to at least know exactly the benefits or the downfall of it. But let's get into this.
Predict that Tuesday comes after Monday. I made sure to stay up till 2 o'clock last night to get these cases, to alert the court to what was the state's obvious intention. To put a witness on there for the purpose of introducing out-of-court statements that are otherwise inadmissible, instead of at least admitting that that was what the state intended to do it, advanced a ruse pretext that they were seeking to do so under 8035. It turns out that 8035, given the witness's testimony, could not be employed. And so the state then went back to plan one, the original one all along, of the state reading evidence from written documents and out-of-court statements, including police reports, statements on Instagram, arguments being had, into the record. Through the state's own mouth, knowing very well that it was improper, that the court had ruled that it should not and could not be done, and it does not somehow become relevant because they declare hostility, which they knew about from the inception. The state made a representation to this court that it was a complete surprise. That's not a credible statement. I think it is incumbent upon this court to discern the veracity of that contention. There was a witness there, happened to be Ms. Holmes's lawyer. He's present. The state essentially tried to circumvent the rules, circumvent the order of this court, and testify to this jury about documents and information that it wanted to put before the jury, which it found no permissible way to do. The court warned the state, I don't want you trying to go through the back door, which you can't get through the front door, and they launched immediately into that pursuit. The jury sat there while the state made implication after implication, introduced admissible evidence after admissible evidence to the substantial prejudice of this defendant. And so not only did they do it after we raised the issue, they did it after the court ruled against the state and admonished the state not to do just that. And they launched into that pursuit. Mr. Devins has been prejudiced. This jury sat there and watched this fiasco unfold with at least 10, maybe 15 sidebars after every 2 questions, with the implications that were being all predicated on the implications and the inadmissible testimony that Ms. Bradley herself read into and spoke into the record. And for that reason, we think that it was deliberate. It is highly prejudicial. This jury has been tainted, and we move for a mistrial.
All right. So, okay, I couldn't find the video that's gonna unless we just watch one of another case, which I don't really want to, you know. So we're just gonna go with rule of thumb here, okay? Everybody put your input in. Everybody should understand what a mistrial is. Basically, somebody did something wrong, right? That could be not in favor of what's the word? A fair trial, right? So just now, before I press pause, you heard the defense attorney said basically they what was the word, he tainted the jury, right, with speaking on stuff that was already deemed inadmissible, including photos and everything like that. So I think we're at a good understanding, at least to continue. Now, let me get me a Word document pulled up, because now it's time to have a little entertainment, and really put our minds to work, right? Because again, we don't know exactly what's going to come out, or if it's even going to be beneficial, right, to Melly to have a mistrial. Hold on. Okay, share that one. So hold on, y'all. I'm trying to get my my Word document up so that we can get this together. Exactly. Thank you, Prince. So yeah, I want y'all to help me out with this, because again, I definitely never followed a case that ended in a mistrial for sure. So this will be my first time even seeing how it plays out. Now, I know a couple questions that I have, is, right, if a mistrial is given, does that mean that YNW Melly could get out, right? And if not, does he sit longer? Because again, we're like 4 years, almost 5 years in this thing and just not going to trial. So it's like, and I say we, but him, sitting there like, what comes of that? Like, what is it? Right? So that's why I kind of had wanted to find out exactly what normally happens, but I can't find it. All right. Let me share this. So far, and y'all help me in the chat if I missed something. So far, what we have as evidence towards YNW Melly, right? We have video. Right? We have video of him getting in left rear of the vehicle, right? We have cell records of phone in his name and in the vehicle. Let's see. Prince says depends if the defense argues that they were beating the prosecution so bad that they intentionally taint the trial. In that case, the prosecutor cannot try him again. Now, I could play some more, because didn't he say, hold on, I'm glad you said that. Let's go back to the audio real quick, because I think he says that at some point. Let's see, hold on. And then we're going to get back into the notes.
Could not be employed. And so the state then went back to plan one, the original one all along, of the state reading evidence from written documents and out-of-court statements, including police reports, statements on Instagram, arguments being had, into the record. Through the state's own mouth, knowing very well that it was improper, that the court had ruled that it should not and could not be done, and it does not somehow become relevant because they declare hostility, which they knew about from the inception. The state made a representation to this court that it was a complete surprise. That's not a credible statement. I think it is incumbent upon this court to discern the veracity of that contention. There was a witness there, happened to be Ms. Holmes's lawyer. He's present. The state essentially tried to circumvent the rules, circumvent the order of this court, and testify to this jury about documents and information that it wanted to put before the jury, which it found no permissible way to do. The court warned the state, I don't want you trying to go through the back door, but you can't get through the front door, and they launched immediately into that pursuit. The jury sat there while the state made implication after implication, introduced admissible evidence after admissible evidence to the substantial prejudice of this defendant. And so not only did they do it after we raised the issue, they did it after the court ruled against the state.
The prosecutor made a lot
of do just that. And they launched into that pursuit. Mr. Dennis has been prejudiced. This jury sat there and watched this fiasco unfold with at least 10, maybe 15 sidebars after every 2 questions, with the implications that were being all predicated on the implications and the inadmissible testimony that Ms. Bradley herself read into and spoke into the record. And for that reason, we think that it was deliberate. It is highly prejudicial. This jury has been tainted, and we move for a mistrial.
All right. So I think so. Y'all correct me if I'm wrong. I kind of got from that it is being put on the table that it was on purpose, that because the judge ruled out in particular the 2018 statement from Felicia Holmes, right, which was, in my opinion, a big chunk of the case, right? That's why they went through so much to make sure she was there. I would say, that's a big blow. Let me see. Only problem is he needs to prove two things to be granted a mistrial, that whatever was done was okay. Whatever done cannot be corrected by jury instructions from. I mean, to be honest, I would say they presented that, because if we think about it, he referenced Felicia Holmes, okay? So if we go off of, let me put that back up. If we go off with Prince, now Prince, where you got that information from real quick before, like, I know you be good at what you do, but I just want to, where you got the two things from so that it can be on record. Nevertheless, I know Prince will put in the thing. So if we just go off of that, so if one is whatever was done was y'all just don't be understanding how hard it be sometimes for me when I be talking. Cause now, why can't I say that word right now? Anyway, I'm gonna keep going. The truth and y'all know how it go, okay? But so if one is that, so based on the wording that the lawyer used, then that checks that off, right? Because although the prosecutor tried to do a hostile witness for Felicia Holmes, she also said or referred to a lot of the original statement when she wasn't supposed to, okay? And then second is whatever was done cannot be corrected by a jury instruction. It can't. Once you hear it, because, okay, in my mind, right, if I'm sitting there and say the witness comes on, right, they say, here comes state's witness, Felicia Holmes. So I'm like, okay. They ask questions like her seeing him on FaceTime, her this, her that, right? And then they say, oh yeah, and did you talk to the police in 2018? And then they say, well, whole objection, and then they take us out the room, right? So we go out the room, and I'm like, dang, I wonder why they took us out the room, right? And then we come back in, and the question is asked, and then I hear the defense like, objection. You can't mention that. So now I'm like, ooh, why you can't mention that, right? So then they continue, then I'm hearing the question asked. You know what I'm saying? Like, in my mind, just if I was on a jury, I would still remember what she said, or I would still have some type of curiousness to that piece of information. And possibly when it's time to actually deliberate, that still may be in the back of my mind. I mean, I'm just being honest. What about y'all? Like, I will be honest. So with that being said, I definitely think the defense has grounds for a mistrial. Now, do I think it would be good to get a mistrial? I don't know. Because I kind of feel like, and y'all correct me if I'm wrong before we get back into everything, kind of feel like if the case is so, was it different? Okay. But if the case is so, like, not going well, right? Maybe finishing it out. And what if he just get found not guilty? Then you can avoid even, having to be retried, right? And then another thing though, but like, would that be even, I don't know if I would want to, throw it up if I was on, death, for the death penalty. What's up, King 10? I also say, yes, that's what they want, a mistrial, but the judge is saying the defense is winning. So, right. Prince said defense has momentum. Yeah, so I'm kind of feel like, and one thing that stood out to me, right? And then we'll get back into it. It's just how the judge is like, make sure your client, you know what I'm saying, understands. I don't know. I've been sitting in jail, say, for 5 years almost, right? We're at trial. Obviously, everything they said, even if we just go back to 2019 at the original Arthur hearing for Bortland, all of what they said they had then that wasn't even strong enough to keep Bortland in jail and not get bond is now being presented. Mine is a lot, right? Mine is a lot. I don't know, man. I mean, you never know until you're in that seat. But personally, just me assuming, right? And just trying to indirectly put myself in that position, I may want to keep going with trial, right? But I know that's easier said than done when you're not sitting in the seat. I don't know what y'all think. If y'all wasn't as far as what we know, right now, would you want to get a mistrial or would you want to continue? Because personally, I just feel like the case is weak altogether. I felt like if the evidence they had back then, now mind you, they done said some big things at the Arthur hearing, right? They said, for one, without a doubt, Fredo Bain was the one that picked up Melly, right? But then now they're saying, they're not even saying that. Now they're saying, oh, he just sent, the address or whatnot. Another thing that they said back then was that Bortland didn't have any GSR. Now they're saying Bortland did have GSR. So it's like, like I said, I would say I will probably continue with trial just based off what I know on, or what I assume on case law, right? So y'all tell me what y'all would do. Would y'all want to continue or would y'all just want to get a mistrial? Oh, hold on. Let me check my email real quick. All right. Y'all make sure y'all like, comment, share, subscribe. Tell a friend to pull up. We are still going at it. It's only, 10 o'clock Eastern time? Hey, I'm feeling good. We've been at this thing about 3 hours and some change. Let's see. About 157 people has came through. Our lights are doing well. Shout out to the truth team that been holding it down. I know a lot of us got to work tomorrow, so I appreciate y'all, Let me see here. What I was about to type. So look, I'm just definitely trying to just get the best understanding. So tomorrow we will be ready and understand what we're hearing, right? What it do, Loud Pack? And I actually just got your email too. I'm gonna respond when I get off live. All right. So I want to say this. When I look up benefits of, let me just share it. So when I look up benefits of mistrial, defense knew she was going to pull this, so they ready for a new trial. That could be it too, right? So a mistrial says, in essence, temporarily leaves the case in limbo until decisions can be made about how and when to move forward. Depending on what prompted the mistrials, most cases will be retired again at a retried at a later date. This can benefit the defense. Let's see what this is. After a mistrial is announced, one of three things will occur. Another trial is scheduled for the future on the same charges. Now, this is for Texas. I don't know because it's not the same thing, but we can at least kind of look at it for a little guidance, I guess. A mistrial being declared simply means the crown starts over. The case will remain on the court's dockets, and all parties to the case must decide how they want to proceed. 3 possibilities after mistrial: prosecutor dismisses charges, a plea bargain or agreement is made, or another criminal trial is scheduled. What y'all think? If a mistrial is granted tomorrow, what you think will happen from there? What Neach said, it's not odd for them to push things out or converse over the jury. Is prosecution tactic. Okay. Now, I was just about to say that maybe, what y'all think about this? Maybe asking for the mistrial is a way to plead. Because maybe, right, and this is just allegedly, possibly in our opinion, we just playing Clue, you know. My degree comes from law and order, SVU, don't, you know. What if the reason for the mistrial is to just a plea bargain? And what if the prosecutor look at it like, dang, we messed up trying to shoot high on this case before even doing the other case with the same evidence that they said was weak, right? Well, let's just offer this. Do y'all think he'll take a plea? Keaton said they are going to tank him with the phone data and camera footage, so a mistrial won't matter. I don't know about that. And I'm glad you kind of got us a point to get back to it. Let's get back to this real quick. All right. From what we heard in the trial all last week, right? And what we read in YNW Portland's Arthur hearing, right? This is what I have as far as evidence that they're presenting against him, right? They have a video of him getting in the left rear of the vehicle, okay? They have cell phone records of the phone in his name in that vehicle, right? That cell phone leaves the vehicle prior to arriving to the hospital, where the only passenger missing is Melly. Then they have the Texas call from Portland to Melly asking if he had a warrant after he was picked up on murder. And they have, what is it? Ballistics? No, that was, hold on. What's it called? They have, the trajectory. Is that what I want to say? The crime scene basically showing, crime scene showing shots from left rear. Okay. So they have a crime scene reenactment or whatnot, showing that the kill shots came from the left rear for both victims, right? All right. Is there any other evidence that we heard last week that I'm missing? And then we're gonna get into the witnesses. But for right now, evidence, like physical evidence. Is this all the evidence so far? Okay, Neat said the ballistics show that the shots were from the rear. Yep. So it was ballistics. With crime scene, that's what's gonna be my ballistics. Because I was like, is it ballistics? Trajectory? So is everybody in agreement? This is what they have right now. Oh, now, did they throw out the video that they found in the phone? I don't even remember. I'm gonna put the video in phone because I don't remember they threw that out. So they have the shell casings from right. Oh yeah, the shell casing was on the left side. Let me see what else. Glass from inside the vehicle, match glass from the crime scene. Glass. Then we got Melly got out the car and walked around. They can prove it with the phone data. The prosecutor, when Melly called his girl mom from the putting him okay. So we ain't gonna get into the phone, the mom thing yet, but I got you. Okay. So what Keeson just said. Okay, yeah. Let's put that up here too. All right. All right. Is that it? Let's see. Okay. Burn marks on left seat showing the gun without close. Okay. So let me see. That's on. All right. Anything else, y'all? So far, this is the evidence that we got. Just to Melly, not Bortland, just Melly. We got the video at the studio of him getting into the left rear. We got the cell phone, the cell records of phone in his name and in the vehicle. That same cell phone leaves the vehicle prior to arriving to the hospital, and the only passenger missing is Melly. We have cell phone records show Melly's movements, right? Based on the above information we just went over. The text is called from Bortland to Melly asking if he had a warrant after he was picked up on murder. The crime scene showing shots from left rear, meaning the ballistics and all the reenactments that they got, right? Then we have the close range shots for YNW juvie. Then we have the video in the phone, right, that shows allegedly him admitting to the shooting. And then that shell casing that was in the left rear in the white bag. Is that the evidence? I think that's about it. If we think of something else, I'll add it. All right. So let's go now before we get back into the actual witnesses, right, that maybe provided testimony in some way. Let's just go through each one of these, and I want y'all to help me, right? Which one would you need an actual witness to testify to it for it to be a strong piece of evidence? If you get what I'm saying, okay? So again, everything we just put down, now we're wanting to find out which piece of evidence needs a witness to corroborate it, or which evidence can stand alone, okay? Y'all get what I'm saying? What evidence needs an actual person to say, yeah. Okay? All right. Now, video of him getting in left rear. Do we need a person to physically testify to that? Personally, I'm gonna say no because it's on video. Y'all agree that we don't need a person to corroborate the video of him getting into the Jeep? Okay. Now, the cell records of the phone in his name and in the vehicle. So I'm going to say no, because a phone just being in somebody's name and in the car don't technically need somebody to say, because that was what the phone company would verify, right? In my opinion. And then remember, it's two phones in there anyway, because one of the victim's phones was in his name. So my vote is no. We don't need a person to corroborate that. Next, cell phone leaves vehicle prior to arriving to hospital. Only passenger missing is Melly. Do we need a witness to corroborate that? I'm going to say yes and no, right? My yes is, how do we know Melly left with the phone, right? And then my no is, of course, the cell data or the cell towers can tell us it left the vehicle. But how do we know the phone was with Melly, right? What y'all think about it? Prince said no. Okay. Anybody else? All right. So next is Texas call from Portland to Melly asking if he had a warrant after he was picked up for murder. I mean, that's a given no, because they have that on audio. So I'm gonna say no to that one. Next, crime scene showing shots fired, shots from left rear, right? Do we need a witness to corroborate that? Personally, I'm gonna say no. We don't need a witness because no. No. Yes, you would need the crime scene person or the coroner, right, to testify to that. So I'm gonna say yes on that one. Yep, expert. So let me see here. Let's give it some color. We're gonna color it that. So lime green is gonna be expert. If we get to one with just a regular witness, we're gonna do it yellow. So close range shots, I'm gonna go with that. Would have to be an expert witness also. Now, video in the phone where he admitted to the shooting. Now I know y'all probably gonna be like, Mickey, I'm gonna tell y'all this. I personally am going to say yes, right? Because in my mind, how do we know without a doubt that he is talking about the murder and not like making a song? I'm sorry, I know. But that's not okay. Prince. Like, I'm gonna put it in yellow, okay? Truth, I'm gonna put it in yellow because I kind of feel like that's definitely got to be corroborated for it not to have no reasonable doubt. All right, shell casing left rear. They already talked about it, but I'm gonna say an expert would need to speak on that, right? All right, so I mean, to be honest, once we put it down like that, I honestly felt like we was gonna need more witnesses to corroborate a lot of this stuff, right? So based on us over here, the glass match will be an expert too, which they already showed. But it's not. Hold up. So I ain't turning around. All right. It's not as much as I thought that needed to be corroborated by a witness. Now, before we get into the depositions, what would need to be corroborated? And I'm gonna tell y'all, like I said before, definitely, if I was on the jury, for me to render a guilty verdict, right, I would need to have someone tell me or somehow some type of explanation to why Melly is not in the car at the hospital. So that would be one question I have. Why? Take that color off. Why is Melly all right? And y'all got any questions at this point? Like what question, if you were on the jury, would you have at this point based on everything we done went over? Definitely why. My thing is, why is Melly not in the car in the hospital? Another one would be, how do we know Bortland was in the driver's seat the whole time? Let's see. Another question. So why is Melly not in the Carter Hospital? How do we know Portland is in the driver's seat the whole time? Is that what's up, Trend? Trend, is that a question for the case, or are you just asking the chat about that? Trent said, who else is a huge fan of Melly? DNA evidence. Okay. So Prince says DNA evidence tying that phone to Melly. Okay. Is there DNA tying that phone? Let's see. Keaton said, nope, if Tory Lanez got locked up for shooting Megan in the foot, these you know what? Prince says facial recognition data from facial. Hold on. Okay. Loudpat said, well, no one said he never used it. Well, yeah, that's true too. So I guess it would be, that's what I want. Wow. Okay. Let's see. Is there anything else? I think that would be about it though. Like to me, so the biggest question, right, stems around that phone, right? And another thing is, where is Melly, right? That's the biggest question. Where is Melly? Because we can't forget that this phone in question is being used, okay? And what's against the defense is not only is being used, it's being used to contact people in Melly's inner circle, the girlfriend, his mother, his friend. You get what I'm saying? Like a lot of like, although we can't without a reasonable doubt for sure, concrete say, yeah, Melly had that in his possession. But remember, on day one on the trial, hold on, let me see. Prince says, who picked up Melly? And if they are tracking the phone, where did it go? Shouldn't they be tracking it? That is a good question. And I would say, you know, okay, hold on. Who? Now, this is what I will say for that, right? That would be important, right? Because so far, on 2 different occasions, we have 2 different names. We have Fredo Bain named mentioned as the person who picked them up in the Arthur hearing, right? But then in the original arrest records of Melly and Portland, they have 100K track as the person who picked up Melly. So it would be important to know who picked up Melly, because guess what? That will be a big part of the puzzle. You know why? Because if that person, right, is on record admitting to picking up Melly, then guess what? We have an eyewitness to not only him being picked up in the area they're saying he was, but they would have saw firsthand if he had blood on him. Okay. So that would be very, very important, right? If they actually, without a doubt, have that person, right? Now, Live Pack says, opinions of self-time is really that accurate. Now, our truth team, you know, nerds in the chat said they are pretty accurate. So, I don't know. See, our thing is, we just need to know for sure if he was with that phone that night. Then it says, so Nietzsche said, check the bill for DNA. Now they did. Now, this is the thing. Why I feel like, okay, And I don't know, did anybody answer me earlier when I asked, did a blood expert come yet? Because I was going to say this. So Nietzsche, at one point they do say it. Now, Nietzsche, I will say this, though. The reason why I'm like, because in 2019, they do mention him as the person who picked him up in the Arthur hearing. We went over that tonight. But in opening statement, she don't say it. She just says he got something, the location. So I wonder if they got evidence to show that that wasn't the case or what. But nevertheless, it's definitely in there, in the document at some point. So this is my thing, right? Of course, his DNA will be in the car because we see him get in it. But my question will be, is his DNA mixed in the blood, though? Right? That would be a good question. Like, is Melly DNA where or intertwined with the blood? Can place you in a car but not in the seat of the car, etc. Okay. Keaton said, what is Melly's alibi where he was during the murder? Can anyone corroborate that? And that's the thing. Melly never provided a statement. I have yet to hear of an alibi. So that's a good question. Now, the only time we did hear of some type of story was in the beginning, right? Where the friend said, oh, he got out the car, right? But they proved that was a lie. So I ask y'all this, right? Oh, hold up. So hold on, y'all listen to this. Did, what's his name? Did Weathers so Weathers definitely placed Melly in the car, at least to the point they go separate ways. You know why I say that? Because if he originally said, once he got caught in the lie with the video, he then said Melly had him stop on the interstate so that he can get in his car. He wrote him on Snapchat, right? But then they later found out it wasn't no message on Snapchat. But does that still now verify that Melly was still in the car past the point that they separated? Interesting, right? Okay. And then another thing I want y'all to think about too is if Melly provides this, I guess, defense of why he wasn't in a car during this time, who was using the phone? That's still the question. Who was using the phone? Because although we can't, without a doubt, put the phone in Melly's hand, it's in somebody's hands, right? And I feel like that's important. Why? Oh, that's true, Prince. We can't see who in the back seat of the Mitsubishi. Even the security person stated they couldn't see. But the downfall is the statement. If the person who provided the original statement that was driving that car, if they cannot, without a doubt, confirm that in an actual sworn statement, I don't know if that's going to fly. Right. So that would be definitely something to think about. Because, like, if you're not using the phone, who is using the phone? Did someone else get in the car when you got out the car? You know what I'm saying? Like, somebody has to be replaced. Now, let me just try. Let me see what my degree from Law and Order gave me. Let me see. Let me think of a scenario that would be plausible in this situation that would put the phone. See, the thing, because remember I told y'all originally on day one, my theory that maybe Melly was running away, right, from the situation. I mean, technically that could still be plausible, but that would have been putting emphasis on this homeboy, though. Okay, look, Niche said his degree is from Matlock. See, yeah, and you know what? Your degree a little bit higher than mine because Matlock was actually a lawyer. See, SBU the police. No, that can't be it though, Niche, because his phone couldn't have been left in the car if the car pulled up to the hospital and they're saying the records show that the phone is not in there anymore. So that's the thing. So my theory originally was Melly got out the car and ran, right, with the phone, trying to get away from the shooter. But then something came with it that knocked it down. I'm like, oh shit, they on their own, because now they're saying they can track his movement, like his steps. So I'm pretty sure they probably could have saw if he ran. And then they're saying that he was stationary until they got to the freaking shootout scene, right? And then they saw that he was moving, right? And then they can prove that they was like riding around with a body. So like, yeah, my whole theory went out the window with that one. I honestly thought I hadn't painted the defense, but yeah, it's holes in that one too. All right, so let's listen to the last part of the mistrial part, and then we're gonna get into the witnesses, and see who could at this point, who could help this case and who could not. Okay. What they do, the truth. So the truth said, they said T-Mobile have a tracker whether sitting still or moving. Right. So that's why I'm like, my whole theory that he ran. I mean, at this point, I'm pretty sure if he ran, that tracker probably could have showed it. But it's like 4 minutes left of the mistrial part, and then we're going to get into the witnesses. And then we're going to see what else we put together and head up tomorrow. So here we go.
If you don't mind, I'll have Mr. Alistine articulate what that means.
This is your motion for mistrial, Fred?
Yes, it's our motion for mistrial.
The second. All right, go ahead.
Yes, second one. Judge, in my entire career, I've never heard the state imply with no evidence whatsoever that the defense team would take care of this witness. And even though the court gave that instruction and told them to ignore it, that question, the defense team would take care of you if you answered like this, is so improper. Not only does it taint our client on the other questions, but it taints everybody at this table. And despite the judge, Your Honor's instruction to ignore it, it's pretty hard to ignore something like that when their entire questioning for the last 30, 40 minutes have been so improper and the court told them not to do it. And they proceeded and proceeded and proceeded. We're moving for a mistrial.
And just for the record, Your Honor, I personally have seen Ms. Holmes in the flesh or spoken to her twice at that deposition and today. Never by phone, never by text. Couldn't distinguish her from a can of paint until she showed up for the depot, and I haven't spoken to her since. So just to let the court know, there is no.
All right, y'all. I'm back. No, Trent, he has not gotten out. All right, let's get into these depositions. All right, so the very first, no, let's go. All right, the very first time the defense, or should I start there? Yeah, let's just start there. So the very first time we see a deposition, right, is a notice of taking a deposition is on January 2nd, 2020. And who do we have? We have Detective Toyota, Detective Bertrand, Detective Tomlin, Detective or Dr. McDougal, which is from the ME's office. All right, next we have. Yes, we did hear that, Keaton, about that. But he said, if I'm not mistaken, that Track gave that money, not Melly, but you know, they're tying it as one. But I thought he said Track. I could be wrong. But I thought that's who he said. All right, so this one is Detective Moretti. If you recall, Detective Moretti is one of the ones from the beginning that was on the case from the start. Trend, did you not just write that? Trend, he's not out. Trend, like, did you not hear me the first time? He's not out, Trend. He's still in jail. All right, let me see. Next, we have detectives again. So a lot of these are repeat too. Just want to put that out there because what the world? All right, let's go. Who is this? Don't know why they got like multiple depositions for the same people. See, same people. They must have had a lot going on during that time frame. All right, what's next? So I'm noticing something right here that they did attempt to do emergency release for medical care, but obviously that did not, go nowhere. But I wonder why before then they didn't ask, I don't know. Let's see here. What's next? Who's this? So these are all expert witnesses at this point that's being called. Police officers that's being called for deposition. Police officers. The truth says they have no murder weapon. The story is a drive-by shooting, remember? Right. But they already broke down why that's not a drive-by shooting. We went over the Arthur hearing with YNW Portland. We went over his transcript for that because the question, right, that we had was why did Portland get bond and not Melly? And we went over that, and that pointed out that they did determine early on that indeed it wasn't a drive-by shooting. However, they said all the evidence that they had was towards Melly, well, the co-defendant, right, and not actually Portland. And the judge agreed, and that's why he was able to get bond and not Melly. All right, y'all. I done made it to 2021, and it's still only detectives and the medical examiner. But as soon as I find one that's not one of them, I will share it. Okay, that's police still too. Did I do that one? Start here. Police. 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 Yeah. All right. So early on, it's not a lot of, other people being called to give depositions. Because I've looked under a lot of these so far, and none of them are anybody outside of law enforcement just yet. However, that is going to change, and the reason why I know it's going to change because it's depositions available online from many people that's not the police. But what we're going to do is determine everybody that provided a deposition, will they be beneficial to the prosecution or will they be beneficial to the state, is what we're getting at. These are a lot of police officers that they call for depositions. Jesus. All right, what's next? Now we're into mid-2021. Now we're getting somewhere. Now, these people here, I don't know who they are, but they don't have, the past ones have their, like, if they'll say PD or it says ME. So these are the first set of people that do not have any of that next to their name. Okay, so these are 3 people, and it's for deposition. And it says the defendant will be taking depositions. So possibly they already gave one to the prosecution, or possibly they were just called by the defense altogether. Now, maybe it's different because now that I look at the next one, Moretti, which we know as one of the detectives on the case, is now listed without the PD next to it. So I wonder what made them change it, because early on they had PD. Now it's like it's not that. So I can't tell you that part. What I can tell you is these are the people they have listed to do depositions. Now I'm going to see if I can find any other people that we came across so far in the reports early on. Early on. Now, I will say this. I don't know what's the importance of this, but I saw it one time before. It said video visitation. And both of them from May 25th, 2021. And it's the video from it. I wonder why that's important to the case. Anybody want to guess at that? Why that's important? Now, another thing that I just saw, right? Now, Melly was arrested in February 2019. However, it is now October 14, 2021, and motion to take oral swab of the defendant was filed from the state of Florida. I wonder why it took that long to request it. I still feel like the more I read this, it's like just showing they were just focused on like everything for the death penalty instead of the actual evidence to even secure this case. But that's just my opinion. Now, this is the first time that Felicia Holmes, which is the witness that took the stand a few days ago. And that is showing that originally she was scheduled to be make a deposition, November 30th, 2021. What's next? All right, now we're seeing a request for deposition for Mariah Hamilton, which is the girlfriend and also the daughter of Felicia Holmes. Originally November 24th, 2021. Now, 2 days after that filing, this was filed with the court, which is, bring it up. All right. This is the state's affidavit for insurance of order to show cause, okay? And this is what it says. Now, this is, again, look at the date, October 27th, 2021. It is outlined. The affidavit for insurance of an order show cause directed to Felicia Holmes, requiring Felicia Holmes to appear before this honorable court to show why Felicia Holmes should not be held in indirect criminal contempt of court, as grounds therefore will show the following. Felicia Holmes. Witness Felicia Holmes was served with a mandatory subpoena requiring said witness appearance before undersigned Assistant State Attorney on October 20th, 2021 at 1 p.m., which is that form I just showed y'all, right? Then it says that investigator Bruce Dowdy of the State Attorney's Office served the witness on October 1st, 2021, 7:45 a.m. by posting the subpoena upon her residence, right? And then it goes into the statute in Florida that states that a criminal witness subpoena commanding the witness to appear for court appearance may be served by a person authorized to serve process at the witness's residence. If 3 attempts to serve the subpoena made at different times of the day or night on different dates have failed, the criminal witness subpoena commanding the witness to appear for deposition may be posted by a person authorized to serve process of the witness residence. If 1 attempt to serve the subpoena has failed, the subpoena must be posted at least 5 days before the date of witness required appearance. I think that's full of foolery, because how do you know that's really her address though, right? Like, without, like, my thing would be, how do you know I live there? You know what I'm saying? Like, I don't know about y'all. And then one thing I tell people that rely on public records, because years ago I used to work for a company that did furniture rentals, right? Once you stop paying on your furniture rental, right? We did what's called a skip search, right? And it's basically just a report of public record, right? And with that public record, it's going to pull all types of stuff. It's going to pull like possible relatives, possible addresses. But one thing about that skip trace, right? Well, it was called skip trace, not skip search, my bad. Skip trace is that some of that information is not valid, meaning an address may appear because guess what? Maybe you sent mail somewhere that didn't have nothing to do with nothing to you, but you use that address one time, it's going to pop up on that report. So that's why I say again, how do they know that was her, or how did they know that's the address to just post it on the door and say, yo, you've been served? Because one thing about that company that I work for is that although we ran the reports, we had to actually work the report. Hence why I'm good at what I do now, because it gave me a lot of practice, right? So before we could go file with the local courts, civil court, right? It would tell you, like, to verify that the address. Who is that? Giraffe nuts. They say, what you talking about, gang? Are you listening, Giraffe? I am. Hold on, let me see. I'm not familiar with that profile. All right. Anyway, so yeah. So one thing about it is that statute is a little vague because you don't really know. Oh, one bites the dust. We was doing so good. I hadn't had to ban nobody. In a minute. Bye-bye. All right. So back to it. Now, it does say here that the investigator located Felicia's Holmes Mercedes-Benz sedan at this address and went on different occasions. Okay. Well, that's all that then. Maybe that's why. All right. So it says here that counsel for Miss Hamilton, which is the daughter, right, contacted the Office of State Attorney on September 9th, 2021 to state that he was appearing as counsel for Ms. Hamilton. A copy of the same subpoena was sent over to the counsel, right? And the email is provided below. Now, it does say here that the lawyer indicated on a phone conversation with the undersigned that he did not currently represent Mrs. Holmes, but said it was possible that he would soon be representing her as well. Then it says, witness Felicia Holmes failed to appear at the above mentioned location at the above date and time. Definitely. So look, y'all, look, I'm about to go back to the old Mickey Truth right in the beginning. You get two, well, not even old, because remember, I wouldn't even give a second one. You get one comment, you get addressed, right? And if you come back with some foolery on the second time, you out of here. No questions asked, you're out. Okay? So, if you're really confused, first time we can definitely clarify it. But if you come with the second time, we're not even doing timeout, you're banned. You're blocked. All right. So, this is the subpoena that they're showing. Now, mind you, it has one address and then it was crossed out. I know if it was me as a legal person, I would be like, well, how do we know for sure y'all ain't just write that? You know, I'm just saying. That's how I would be looking at it. Like, how do you know that's what was on there? All right, and this shows the email here for Mariah. I have not forgotten about you. I was on the call yesterday afternoon, got buried on the 8 different times since the search warrants yesterday afternoon. Protect Maria, give me a copy of the So it does say they provide lodging and travel arrangements for Miss Hamilton and her mother. In the meantime, I can send the statements, Snapchat messages, and some of the text message conversation that occurred prior to the arrest of Mr. Demons. What it do, 83 box Chevy? I've been close to people. Okay. So basically it looks like to me that they had it together to take the deposition. Then it says, so this is from the lawyer for Mariah. And it says, it was a pleasure to speak with you yesterday. I wanted to remind you to send me Ms. Hamilton's statements and any other relevant information as to relates to her involvement in this case. Please send me a copy of the grand jury subpoena you mentioned yesterday, as she was unaware of being served with the subpoena. Lastly, send me a copy of the report. All right. So, I mean, just right there shows that some type of statement was made. And remember, in the Arthur hearing for YNW Portland, remember, they do put the sworn statement of Mariah Hamilton in there. All right. Let's keep going. Let me see. Is this the same? Because that was filed on the same date. Let me see. Let me see. All right. So basically, it is not the same, but it's the same. So this one is for Mariah herself, right? And it's saying the same thing that it said in the mom's own. So we're not going to go. Hold up. Give me a second. Did I read the other one wrong? Because maybe old girl on the mom had a point. Hold on. Let me close some of these tabs. Hold up. That's crazy. All right. Now look at this. And y'all tell me if y'all call Cal. All right. Hold up. Y'all see at number 4? And it says that Miss Hamilton's Mercedes-Benz sedan. And then it says at Chamber Lane, right? Y'all see that? Now we go back to the one I just was on. And it says Felicia Holmes, Mercedes-Benz sedan is at Chamberlain. So they both had the same car. What it do, Gates? Okay. Prince said that they both had Benz. Do you know where? Because I was about to say, how are they going to use the same doggone car? Okay, so Prince said they both had Benz. All right, let's keep going. All right, so the next thing that we have is supplementary discovery. And that one says the following. So now they have Mariah Hamilton and Felicia Holmes listed as witnesses in the case. And this was on October 27, 2021. Oh, excuse me. It says separate Benz registered. Oh, in the document I was just in? Okay. All right, let's keep going. All right, next we have, let me see what this is. It says courtesy copy of video image provided to Mr. Adderstein on October 28, 2021 via flash drive. Okay, so this is a cell phone extraction. All right, next is the defense motion to squash, right? Let's see. All right, y'all. We have been going strong about 4 hours now. I appreciate everybody. Collectively, we have over 200 views that came across. Truth Team holding steady at our concurrent views. I appreciate y'all. Y'all continue to share it. Tell them to like it on the pull up. And we're going to keep going at this thing. Like I said, we're getting prepared for tomorrow's trial, which I will be streaming live starting at 9 a.m. Eastern time. All right, let's see. So this is the counsel for Mariah and Felicia. Well, they put Felicia Hamilton, but we know Felicia Holmes is the witness that took the stand last week, right? And it basically is going on saying that the subpoenas was not served correctly, and that they should be squashed. I'm not sure if that's quashed. I'm not sure if that's how you pronounce it, because it wasn't, like, again, served correctly. But I mean, we don't even have to really read into that too much, because guess what? Felicia had to take the stand anyway by force. All right, let me see what's next. So there's a couple. I'm looking for some people in particular. Okay, so hold on. I'm gonna click through some of these because I'm looking for. Yes, 83. First time, because I've been streaming after court, but tomorrow I'm definitely gonna stream live while it's going on. Uh-oh, my phone died. So Keaton, I actually did see that too. I saw that YNW Melly's mom did say she had a heart attack since the trial started. And yes, to my understanding, they have not found Mariah. The last time she was on a document was back in, I want to say, May of this year. But as to like what's presented, I don't know if she actually provided a deposition or not. but she is listed. All right, so we can go up some. So here, matter of fact, let me see. That's what I'm glad y'all brought it up because I was supposed to look at that earlier to see if it was still on her page or not. All right, let me see. What is her name on here? Dang, I think it's past the time. Who did I? You know what? Shout out to AK-47. I believe he posted it too. So hold on, let me look on his IG real quick. Yep. King AK-47 for the win because he posted it. All right, and this is what it says here. It says, I'm deleting the app. I can't be crying and making myself upset because of a lying clout chaser who won't show his face in court but cares so much. I had one heart attack already because of stress. I refuse to let this kill me. I try to be peaceful and respectful to all of you. I pray for everyone because I know it's the right thing to do. That is unfortunate. Well, for one, let's just say this. Prayers to his mother, because at the end of the day, whether you think he's guilty, whether you think he's not guilty, it still is a family that is going through this with a family member. My dad has, like I said, I'm very candid about that. I went through many trials with my father. And of course, it was always free him, no matter if he was guilty or not. But at the same time, that didn't take away from, other people involved. But I definitely, I can't even imagine. But yeah, I did just see that. I was actually about to click to see if that was really his page. It say, we hate that guy track, shady manager. Huh? What does that mean? Yeah, this the page. But what am I missing? Like, what did that mean? What did that mean? I'm kind of lost on that. What was that supposed to mean? We had big surprise tomorrow. I wonder what that was supposed to mean, though. That was going on. Okay. All right, y'all. Let's get back into it. Now, I'm going to skip straight to this. Because looking through them deposition tabs is taking forever. All right. Back in February 2nd, 2022, the defense filed a motion to exclude, right? And this is who they're wanting to exclude, okay? And it says, and I'm gonna, of course, just not read it verbatim, but it says supplementary motion to exclude state witnesses Mariah Hamilton, Felicia Holmes, and Jacoby Mills from testifying in any hearing and or trial in this case, and as grounds therefore stated below. So let me just point out this. Based on, if we go back, we can go back to what we came up with as far as the evidence, right? Mariah Hamilton, right, can add context allegedly, right, per her statement made to police in 2018, can turn that into a witness verified, right, corroboration, right, can corroborate that. also can show here, can also help corroborate that. And possibly can corroborate that question too, right? The other person was Felicia Holmes, which already testified. But you remember during her testimony, what was the big piece? What is the defense stating as reason to call a mistrial is because the reference to that 2018 statement. So she also can be a witness, possibly, if that 2018 statement, now just her 2018 statement got tossed, could help do that. Now, it's another name that was listed, and that is Jacoby Mills. For those who do not remember who Jacoby Mills is one of the passengers in the red Mitsubishi that left the recording studio. Why is he important? Well, according to his statements made to the police, again, this is not something at this point that we know he said to the actual district attorney directly under oath, but, right, he is the one that says, hey, I was with Melly the morning of the shooting, right? I saw him acting strange per his statement. I then left with Melly, Bortland, and Track to go look for the murder weapons, right? I was there when it was found. I was there when Track got the weapon and said it's gone, right? He could testify to that. What she overheard Melly said to her on the phone to the extent of I was in the drive-by, my two friends were shot. Right. That's correct. So they can speak to that, right? So then it goes from us assuming because he was in the left rear to us possibly knowing he was there if they testify that he called from a wooden area, right? And he was part of the drive-by shooting, right? And that two of his friends was dead. That aligns with what the evidence that the prosecution has. Now, this is why they're saying they should be excluded, right? And the defense is stating that they submitted a motion to compel a better address because they were unable to serve the witnesses so that they can provide a deposition, right? And then it says here that it became a moot point because the state filed, hold on, y'all, I gotta blow my nose. So it becomes a moot point because they then file a discovery providing new addresses for the four witnesses. Okay. And that was on. Yeah. So then they said the defendant incurred costs to serve all the witnesses, but was unsuccessful. They said witnesses are essential in order for the defendant to obtain a fair trial. He has exhausted all means to accomplish this, as the state of Florida has refused to accept service of these category A witnesses. Now, anybody in Florida know what a category A witness is? Because when I saw that, I was like, well, what is a category A? Let me see. Category. Let me see if Google knows. Is that what that means? So according to Google, right, it says a category A witness. Well, hold on. So it requires the state to disclose as category A witnesses, expert witnesses who have not provided a written report and curriculum vitae or who are going to testify. How would that be an expert? Unless it's an expert to what they saw, right? Hold on. Interesting. Let me see. Why would a regular person be an expert witness unless it's to the effect because their testimony is about something they know firsthand? Who better know firsthand? I guess. Is that what y'all getting from them being listed as category A witnesses? Definitely, they will be very important. So I wonder if that's why they were being considered category A. And as we saw on the other document, they do have on the discovery document, they do have their names listed with A's next to them. But you know, oh, let me show y'all. See, they do have them listed as that. And see, when I originally saw, I just thought it was definitely very important people to be listed as A, but the actual definition shows that. So, interesting. All right. So far, Felicia Holmes already testified. So let's see about the other two. All right. So somebody else name that's listed on here that's not listed in the original motion at the top is Trayvon Glass. Trayvon Glass is the person that also was in the car, the red Mitsubishi, right? Remember when we went over the original arrest warrant, it said that he possibly was one of the ones who gave a statement, but it didn't specify exactly if he did or did not. Now, what it says here, that in this motion, right, they wanted to exclude him from testifying. So what I wonder is, when this motion was filed, when was it filed? January 18, 2022. And we go back up, this was where's the date? So about 2 weeks in between. So I wonder if the last person had already testified then. Not testified. Provided a deposition. Because he's on this one, but not on the next one. So I don't know. Let's see here. So it says here that both Jacoby Mills and Trayvon Glass were set for deposition on January 12, 2022. But because their subpoena could not be served, their depositions were canceled. And it says here, the undersigned counsel requested that Broward County State Attorney Office accept service of the above listed A category. That she was not authorized to accept subpoenas. So basically, they tried to serve Felicia Holmes and Mariah Hamilton at the state's attorney's office, but they couldn't accept the subpoenas. Although they were able to find them for their behalf, right? Let's see here. Okay, what's next? Notice a hearing. Okay. So this is the original discovery. So that means the state submitted this as discovery and all of them are listed as A. But this is my thing. Now, the Glass person, I don't know. What could he provide is the question. Now, we know from the statements to the police what Mills said, but I don't know what Glass had to offer. So this is saying, they were unable to serve, and it says current resident is husband and father to Felicia Holmes. They said they moved out 6 months ago, gave no contact information to me. So he ain't in the self service for sure. Who is this for? Uh-oh, my phone about to die. Hold on, y'all. All my phones going dead. I'm gonna have to get off this phone real quick. All right. And they tried to serve her at her job. I know that was embarrassing. And I think she spoke to that on stand. And who is this for? Yeah. Oh, they tried to serve Jacoby Mills, but no one got there. Yeah. So, from my understanding, right, if Jacoby Mills never provided a deposition, right, and never was served to be a witness, does that blow the case too? Because he said a lot of things in his original statement, allegedly. All right, let me see. That's more so the death penalty. They list what a category A witness is. In which one? I still got that pulled up. Where they listed at? Alibi witnesses. Where you see that at? Where do you see alibi witnesses at, Prince? All right, let's see here. All right, what is this? Hold on, the second one. The second one. Eyewitness. I don't see where it said eyewitness at. A definition. Hold up. Cause maybe I'm tripping. Cause I don't see where you see that at. I don't see that. But, you know, I'm going to keep going. I don't know where that was at. Maybe it was on another one I had up. All right, let me see. What's on this one? On the other hand, if this court were to grant motion to suppress, you on the link in the chat? Oh, no. What link was in the chat? So this is admissibility of co-conspirator statements, which was the one they already played from Portland. Okay, so basically they were saying they was using all statements made, which included Portland, which included the other witnesses. This is interesting. Who is this person? Says here, the court have been aware of deposition scheduled with the assigns. The deposition calls for the second currently pending for to be counsel for the purpose of line of defense of multiple witnesses on February against. The word I mean, who is that? this court have been made aware of the sciences. Oh, so she was working 2 cases. Okay, I'm gonna say, what? Who is that? Okay, got it. It's why I want to fit the category. Oh, got you. Put that up. All right, let's see. What's next? Today's clue testimony. All right, so now if y'all recall, originally this case was supposed to go to trial in 2023. Not 2023, 2022. But it did not because they had the whole issue with the death penalty. Okay, so who the world is Christopher Williams? Oh, he's a detective. And they are saying he should not be used as a witness in this case, right? And it's basically stating here he is part of the crime scene report. The arguments here. I want to think, is this the one that did the whole recreation where he was like, I wonder if this is him. I don't recall, but it was once somebody, right, that they wanted not to have be a expert witness, and he did something with recreating the crime scene or something. I can't remember. All right, y'all. Let's see. So far, I found, right, just those 4 names of witnesses. Mine is, of course, the obvious, like, right? If Bortland decided to, like, take the stand against Melly, that definitely would be detrimental, right? I'm still shaky on that 100K purse. I don't know. Like I said, no charges against him has been filed. I think he's not even listed anymore besides that document from March of this year, since like 2020. So I am, though, curious to know what he said in his deposition, though. I am curious. I ain't gonna lie. I am curious to know that. All right, y'all. Let's get into, let me see, what time is it? I think we got time to get in one of the transcripts real quick. All right. So boom, let's get into the question at hand. What we know now, right? We already went over what we feel is the evidence against YNW Melly, right? We even broke down to what we believe a witness will have to corroborate and what technically can stand on their own. So far, we do know the 2018 statements, right, provided by the top witnesses in this case, which will be Mariah, who is the girlfriend, which will be Felicia, who is the mother of the girlfriend who already testified. And remember, her 2018 statement was thrown out, and they're using it as a basis for a mistrial because of the prosecution trying to refer to that statement so much, even after the fact that it wasn't supposed to be mentioned. Jacoby Mills, who we do not know at this point if he provided a deposition. However, in the earlier stages of the case, he is the one that basically put Melly, Bortland, and Track and himself at the scene of the crime the next day looking for the murder weapons. He also provided in his statement that he actually physically saw the gun being taken by Track and taken away, right? Now, the next person is Trayvon Glass. I personally do not know, per the paperwork, what significance he has to the case. Now, as I told y'all before, it is being alleged, right, that Adrian, what was his last name? Hold on, y'all. Can't think of what Adrian's last name is, but the other person in the car, that he provided a statement or a deposition also. Not sure what significance or what information he will have. We do know that 100K Track does have a statement on file. We don't know what he said. Now, we also know that Fredo Bang has a statement on file. Now, again, it's a few people that say they have the actual transcripts that I have not received it. I sent my money, just haven't gotten it in the mail yet. However, we do know what questions he did not answer because it's listed in the motion to deny the compelling of him to answer it, right? Who else am I missing? Let me see what Gates saying. They know if Melly got in the other car or not. Yes, they do know he did not, based off testimony. Not testimony. Let me stop saying testimony. Based off the statement in 2018 from Withers, who first said Melly got in the car with him, but then after they showed him the video from the studio, he clarified that that never happened. So they did rule that out. Yeah. So who else? Now, we also do know that YNW Melly's mom has immunity because she was going to be charged with tampering with witnesses. What she said, we don't know. Okay. Could it be something that could cause harm to Melly? We don't know. What we do know is that during this meeting with detectives and the state attorney, right, they took her phone and she requested that to be back, given back, but that was denied. So hopefully, it's nothing of like issue in that phone. Let's see what else. So as of right now, y'all, do y'all think a mistrial is better in this case still, or do y'all think just continue on with the trial? I personally felt like, hold on, y'all. I personally feel by never being in that position to face the death penalty, okay, but just trying to think about what's going on, I feel like currently is a win for the defense, right? And would I want to start over and possibly have to wait 5 more years before even getting my fate? Or would I just want to continue with the trial, right? And just say, yo, y'all gonna find me not guilty. Box Chevy said mistrial. Now, Box said, I can't talk. Box Chevy. Why do you say mistrial? Because my thing is the looming of, like, we don't know what happens afterwards, right? It's 3 things that could happen. GTA said go all the way. And I'm kind of on that too, because it seems like the evidence, I just, again, never been in that seat before, right? So I don't know how it feels being in that seat. But it just seems like all that evidence that they said was so strong in the beginning is proven not to be strong. Even the evidence that they originally took to the Arthur hearing for Bortland, right, that the judge ruled was weak even towards him, right, is now the same evidence that they have to Melly. And if y'all recall, when we were reading the transcripts of that hearing, all we kept hearing was Melly, 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 right? And then right now, all we're hearing in Melly's trial is Bortland, right? So Prince says that's all they got. I'm taking all the way, especially with this much momentum. Yeah. I mean, of course, like I said, I've been trying to find something that can explain to us the pros and the cons of having a mistrial. I just don't know though. Just using my mind, right? What I do know about mistrials is possibly is it one of those things where they want a mistrial to at least get a plea, right? Get some, because unless they got some smoking gun, unless, like I said, yeah, if Track take the stand, if Bortland takes like somebody like that, then yeah. If Mariah is somewhere hidden in like Fort Bragg somewhere and they have her that can without a doubt pinpoint him being on that scene and saying what she said, or if the person who picked him up is going to testify. Because again, if the person who physically came to that location picked him up, he would have been able, he or she, because whoever would have been able to see him fully clothed with blood, allegedly, possibly, right? Would be able to like pinpoint a lot of missing pieces, Exactly. I definitely feel like, it should be more evidence. The prison, I don't think they can have another trial. Right. Now that's true. That's true, Gates. Because everything to me is definitely circumstantial, right? Because to be honest, even before I read the Arthur hearing for Bortland, I felt like they had more evidence towards him than they do Melly, right? But then the court ruled at that time they had no evidence against him. That's why he was able to be granted permission to get a bond. So, this is something. I thought by starting from, because I feel like we closed the gap. We kind of are up to date, right? We know now, at least for Felicia Holmes, the 2018 statement is out. I really felt like since the beginning, those statements from 2018 for all the A witnesses, right, would definitely have issue. But what I want to recall is, remember when we was reading the document for Bortland where it broke down all evidence presented, right, to the court and on behalf of the state. Some of them names we didn't know. So I wonder if in their statement they provided something that might be against Melly. Now, remember, the only name we saw out that I recognized was Track's wife. What could she have put out there in her statement? You know what I'm saying? I don't know. To this moment, if I take it back over here. Oh, let me show y'all this. So it is, if y'all see right here, these are transcripts. And I believe this one is the one of the detective. I went over this one in my February video. Yeah, Moretti. Moretti is that detective that started from the start of the investigation. I'm not going to go into it because I went into it in detail in February. So just check that video out. What I will say is this is the transcript where you will hear the names that we heard before, like 1090J. Name dropped is in this, Fredo Bain name dropped in this transcript. Jay Green, which is one of at some point Melly's friends, right? If you're not familiar with him, he's a rapper down there in that area. So a lot of people, they get more into the gang culture, right? They get into like where information was coming from. They mentioned 100K track. So this transcript is very detailed. Again, even 1090J, when he spoke on it, said it was just some random person throwing his name in it. He ain't had nothing to do with none of it. So I don't know. But the testimony of YNW, I want to say Juvie, auntie, her testimony or transcript of deposition is in there. His mom transcript is listed in there. So it's a lot of transcripts in there. But again, I went over a lot of them in February. Who deposition is in? Yeah, so like this one is Juvie's mom. So again, I don't know what's the difference between why some are public and some are not. Because like I said, even for the Fredo Bang one, I had to request it. Then they had to send me an email back that said, yo, this is how much it costs. And then when they sent me that, I had to realize I had to send in a money order or a check. And then I had to mail it off. So now I'm waiting for them to get it and process and then mail me back the transcripts. The trial probably will be over. Now, I wish I would have known then that track actually had a transcript, but I am now about to request that. Matter of fact, while I'm on, I can do it now. Matter of fact, hold on, y'all. I think let me just do all of them that's on this list. It's on this list. But yeah, so pretty much that's where we are with everything. Why? Okay, I'll do it when I get out because I don't know what's popping up. All right, so that's pretty much where we are, right? I just don't see, unless they're hidden, because all these witnesses, although Melly's defense team has filed motions to compel addresses and everything, they all have been denied, right? So it's not, although we don't know, right, from the public if they found these people, we only can assume, right? But as we learn with, say, for example, 100K track, it doesn't say, unless you look in the discovery, that he even is his statement is entered, right? So it's not a place where it says that he has a deposition on file. You just have to see it in discovery. So who's to say any of these other people that are witnesses don't have one in discovery that we don't know about? Are they going to be called to the stand? I just really think it's playing Russian roulette at this point, just in my opinion. I really wouldn't know, or I don't even know which way the judge is going to sway tomorrow. All I do know, we will be live and definitely watching in real time. So it is now 11:44 p.m. We are almost at the 5-hour mark. I'm going to get ready to get up off of here because I need to get my beauty rest for tomorrow, especially if I need to be on time, because y'all know I'll be late. I know. But I normally get up for work an hour before trial, so that's my goal, is to just be up early. What else? I'm trying to look for the artist. So what I've started to do, because a lot of people reach out to me to play their music, especially in my hometown. So I said I was going to start doing that. What's his name? I got to remember his name. So instead of doing my all right, Gates, definitely. Instead of doing my outro, I said I was going to start playing their music. Just to support the local artists, Let me see, what's his name on here? But yeah, y'all, this was a good live. Definitely make sure you pull up. A good live. Look, we got a lot of backstory done. And oh Lord, he got a lot of, hold on, y'all. We may not be doing this one. Okay, we're gonna try. All right. But yeah, we're gonna get into it. We're gonna watch it live. We're gonna talk about it. We're gonna see what's what. I hope this ain't on. So I did an interview with this person, Rico Castro. out of Columbia, South Carolina. I'm actually going to drop it soon. I had waited until I reset, but I'm going to be dropping it soon. He's a local artist here. I do not know what this song is about to say, okay? So anything that you hear on this song is not the view of Mickey Truth or my platform. However, it is, you know, part of their artistry, okay? So just take it as that. I appreciate everybody. Let me look at the stats real quick before I cut the music on. We had 261 views overall. Truth Team hold it steady at about 22 concurrent viewers. We only had 28 likes. I'm gonna need people to start liking. Come on, it don't take that much to like it. But nevertheless, yo, we are doing better and better. And with each live, we've been at this thing for 4 hours and 54 minutes. By the time this song finishes playing, we'll probably be at 5 hours. I appreciate everybody. And I will see y'all in the morning, 9 a.m. Eastern time. Holla!
Soon as I got them handed to him, goddamn, he gonna give me the bag. Y'all boys just go get the money back. You know how we gonna do that shit. All right, say this, goddamn. Just hit me, bro. Goddamn, I'm about to set that shit up now.
Tell him this bitch retarded. I have to give him at least slice of this.
No cap, this shit no cap. If a nigga play with me, he won't have no cap. And I can't go to jail at 24 like Kobe Crash. But if a nigga play with me, he won't have no cap. Hey, no cap, this shit no cap. If a nigga play with me, he won't have no cap. And I can't go to jail at 24 like Kobe Crash.
Rico, what the world? Okay, hold on, y'all. Shout out to Rico Castro. That's not the song he sent to me. I just had looked them up real quick, but that's a little bit too much. So hold on. That's too young for me, Rico. Too young for me. I like the young music, but that one was just a little too young. Let me see. Let me look in the archives, get another one. Trying to do one of the younger. For real, y'all want me to finish that one? Look, it was too young for me. If y'all want me to finish, I'll finish that song out. I don't want him to feel like I was being rude to him anyway. Keeson said that's bumping. He bumping. Definitely hit that like button on the way out. Okay, hold on, y'all. Oh, what's that? Okay. Well, here go another set of young ones. I'm gonna play because I had told their mama I was gonna play it. So I'm gonna play this one too. It's young. I'm gonna let it ride though. So y'all, here we go.
Gang.
BOG for real, nigga.
Pull up, then I back in for that back end, then I sped off. Hello, buddy, running so damn fast, I need your head talk. Pull up with that ARP, don't 5-5, knock your dreads off. I heard little bro got caught for that body, took his mask off. Pull up, then I back in for that back end, then I sped off. Hello, buddy, running so damn fast, I need the head talk. Pull up with that ARP, don't 5-5, knock your dreads off. I heard little bro got caught for that body, took his mask off. Flying through the city and expecting to the tag off. Little bro was doing all that crazy shit and made him crash out. He was all too many damn drugs, made him crash out. When he had got shot, he tried to drive him and he bled out. When he tried to drive, he bled out. And now the feds out. Now these niggas that can't even trap, cause the feds hot. All that bullshit, these niggas talk, these niggas scared now. Cause they know we don't aim at legs, little bitch, we aim at heads now. I don't want the regular charger, bitch, I want the red eye. I remember smoking gas, they said they smoking dead guys. Make them try to bring you down just like you in a crab pot. Your brother talking crazy, caught him low for taking trash out. Pull up, then I back in for that back end, then I spit off. Hello, buddy, running so damn fast, I need your head tall. Pull up with that ARP, don't 5-5, knock your dreads off. I heard little bro got caught for that body, took his mask off. Pull up, then I back in for that back end, then I spit off. Hello, buddy, running so damn fast, I need the head tall. Pull up with that ARP, don't 5-5, knock your dreads off. I heard little bro got caught for that body, took his mask off. Niggas that got caught up for a lot of shit like Rico cases. Niggas think they playing around with who? That's on bro, no faking. No mask on, no fucking chasing. Stupid bitch. 12 got behind me, took them on the taste. Hold on, wait, bitch, no free take K. No, running around drunk, it knock off your face. We did it. Keep up this stick right now, it come off the waist. I can't smoke no blunt with 299. Your shit might be laced. Bitch, we want no racks. Shit, we talking bands. Racks. Bitches come around, gang, they super fans. Super freak. Boys hot as hell. We need super fans. Stupid hoes hot as we deep as hell. We need super fans. Back in, then I spit off. Hello, buddy, running so damn fast, I need your head tall. Pull up with that ARP, don't 5-5, knock your dreads off. I heard little bro got caught for that body, took his mask off. Pull up, then I back in for that back end, then I spit off. Hello, buddy, running so damn fast, I need the head tall. Pull up with that ARP, don't 5-5, knock your dreads off. I heard little bro got caught for that body, took his mask off.